Guess I'd like to call the House Judiciary Committee to order for an executive session, and I apologize to people in the public for being a bit late, but we just had a few things we needed to discuss. And I'd like to recognize Representative Wallace to lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. So the first bill that I would like to take up is HB 379, which we began to address at our last executive session. Representative Reed and Representative Kutab, and I think Representative Alexander and maybe others, Representative Manos, I think, worked on an amendment, and so that is Amendment 347. Is that correct? Yes. So the chair recognizes Representative Kutab for a motion.
I make a motion to OTPA with Amendment 347.
I'll second, Mr. Chair.
All right, so moved by Representative Kutab, second by Representative Alexander. Representative Kutab, would you like to speak to your motion?
The amendment here is just requiring that in the tenant's notice to terminate, which is a standard form that's provided by the state, that the eviction notice must clearly state that the tenant may be eligible for assistance from the New Hampshire Legal Aid for Legal Counsel, and it will give information on how to obtain such assistance. It does not guarantee the right to assistance, just gives them the information that it may be available to them.
Any other discussion on Amendment 347 to HB 379? Seeing none, I think this is something we can do by a voice vote on the amendment, and then we'll have a roll call on the bill itself. So all those in favor of Amendment 347 to HB 379, please say yay. Yay. Any opposed? All right. No one opposed. Motion carries unanimously. Now we're on to the main bill. So it would be HB 379 as amended. Anyone want to have any further discussion on that? Seeing none, I ask the clerk to please call the roll.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman. Yes. Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk votes yes. Rep. Perez. Yes. Rep. Smith. Yes. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
20 yeas, 0 nays.
OTP. All right. So that 379 is OTPA. All right. Next, I would like to turn to House Bill 112, and the chair recognizes Representative Tripp for a motion.
I move inexpedient to legislate.
Is there a second?
I second that.
Representative Tripp, would you like to speak to the motion?
Thank you. I believe there's 3 issues with this bill. The first is that notice is required before sale or transfer of the property, with 60 days notice. That seems excessive to me. Another term of the bill is that the tenants have to be provided an opportunity to meet the terms of that are already agreed upon by the other buyer. And should they be an issue with their obtaining financing or something that would prohibit their being able to purchase it, the period would be extended beyond the 60 days. Probably the biggest problem with this bill is that it doesn't make any accommodation for any tenants that are not interested in participating in the purchase. This is going to make the tenants being able to purchase the property very difficult, because there may be perhaps 10% of the existing tenants that are not interested in buying the property, which is going to make it very difficult for the remaining tenants to obtain financing and any other thing that's required to enable them to purchase the property. Thank you.
Anyone else wishing to speak on 112? Yes, Representative Manos.
Thank you, Mr. Chair. There is an amendment that has been circulated, which I think would address Representative Tripp's concerns regarding this bill. And I would ask the committee to consider the amendment that's before us. It reduces to 60 days notice, the notice to each tenant, and it simply provides them with the information. And notice is considered delivered to a tenant by signature of receipt, notation of refusal, or a certified letter. And so that avoids the issues regarding what the tenants might do upon receiving notice and whether they would collectively seek to buy the property or not. So I would request that we consider the amendment. Thank you.
Right. Well, I mean, I definitely, I appreciate your raising that issue. And if we were to get to the amendment is not on the floor now because we're debating the issue of ITL. But I mean, I appreciate your people can certainly take into account in deciding how to vote what you've said. I guess my own concern is although I guess I would agree that the proposed amendment makes the bill somewhat less objectionable. To me, the bill is, even with the amendment, remains significantly objectionable. And I personally would intend to continue to vote ITL. It just seems to me that we're going to have a number of other bills that are coming along that we're going to be execing, that do sort of the same thing, is that there's, to make it more difficult for landlords to own and manage and dispose of and do all kinds of things with property, in the theory that somehow that's going to make things better in the housing market. To me, it's going to make things just worse. To me, the more sort of conditions and other kind of restrictions you try to place on landlords, the result of that is simply going to be that you're going to discourage people from being landlords, which will mean less affordable housing, or the rents are going to increase. So, although I do agree that the amendment improves the bill a little bit, to me, I would still vote ITL. Anyone else? Representative Alexander.
Thank you, Mr. Chair. I would like to just concur with your statement. I think the big objection I have with this is, although this is restricted property, so 4 units or more, I think that we run into issues when cash offers are made, and somebody may have the cash for a unit that's 4 units or more, and in that case, you can have closings that are 3-4 weeks or even less than 30 days. So this just really puts a restriction on the free market, the housing market. It puts a restriction on the supply, which is what we're looking at. Is we're looking at a supply side issue with this housing crisis. So this regulation just really hurts the transfer of property between people. So I would agree with you, Mr. Chair.
Yes, Representative Smith.
Thank you very much, Mr. Chair. I want to suggest that we should not be conflating two issues. One is the problem that's occurring across the country and certainly in New Hampshire about the shortage of housing, affordable or not, when we have the vacancy rate that we see. That's one issue. But that's something that I'm pleased that my colleague from Ware is going to be looking into with a very specialized, focused committee looking at the housing situation. Separate from that is the rights of landlords and tenants to be involved in a process that is fair to everyone. And this was an attempt to recognize the right, of course, of a landlord to be able to sell property, but also recognize that at the same time, it does have a direct effect on the housing opportunities for tenants. So it's very separate from the issue of availability of housing generally. I'm sympathetic to what you say, but I do think it attempts to solve a problem without regard to housing availability. Thank you.
Anyone else have anything they wish to say? Yes, Representative Perez.
My concern about putting restrictions on landlords is they're gonna say the heck with this and they're gonna flip them to be condos. And that happened in a huge area behind where I live. And if we continue to put weights on landlords, they may just throw their hands up and say, well, I'm just going to sell all my units as condos and then I don't have to worry about it. And that's only going to hurt the tenants because you'll have no regulation basically over what you can do to them. So that's just a concern.
All right, Representative Horgan.
Yes, we've heard, we had lots of hearings on this and other bills, and two things we heard over and over again is, one is, and it's true, the vacancy rate is near zero. It's a fraction of 1%, that rents are much higher than what people can afford. And yet we hear from the landlords that they're suffering. They're barely hanging on. They're on the verge of bankrupt. Well, I guess we never heard the word bankruptcy. So it makes me wonder who's buying these properties. A lot of them are probably bottom feeders because, if we actually do create more housing supply, that'll drive the rents down that they're already apparently losing money giving. So I think this bill, so I'm going to vote no on the ITL. I think the amendment makes it better. It's a difficult issue, but I think, if the landlords aren't making money now, that's the financial situation of the new buyer is going to be even worse, and he's probably going to try to drive the expenses down to pay for the cost of buying the property. So I think it's best to give the tenants advance notice of what's going on. And anyway, and there is a condo conversion. Obviously, the tenants have to have a lot of ample notice of that because they're probably hoping to sell the condos to the tenants and so forth. And there's very detailed rules on that, which are probably much more, I'm not an expert on them, but I understand they're way more restrictive than this little thing we're passing here. So I would just say, given the nature of the market and just the bleak short-term prospects, I think we should pass something to give the tenants a little bit more protection, what's already like a very difficult situation for all parties involved. Thanks.
Anyone else wish to speak?
Mr. Chair?
Yes.
Yes.
Representative
Just,
Di Lorenzo.
thank you, Mr. Chair. Just following up on the previous conversation about condo conversion of a property, for me, that could be an avenue for a tenant to buy a unit individually. So, it's not all black, it's not all white. But that is an opportunity if the tenant can afford to put down in a down payment. Thank you.
Anyone else have anything they wish to say on this bill? All right, I think we're ready for a roll call vote on the motion of ITL. So I'd ask the clerk to please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab votes yes. Rep. Perez, Rep. Smith,
No.
Rep. Horrigan,
No.
Rep. DiLorenzo,
No.
Rep. Eaton,
No.
Rep. Page,
No.
Rep. Macbeth,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Chairman Lynn.
Yes.
Motion fails in a tie 10 to 10.
All right, is there another motion? Yes, Representative Manos.
Thank you, Mr. Chair. Excuse me. I would now move my amendment, or excuse me, it's not my amendment, but I would move the amendment to HB 112, which is before us.
What's the amendment numbers of?
It's 2023-0252H.
So to clarify, the motions ought to pass with amendment. Thank you.
Yes.
Right, okay. I'm sorry, can I just ask one more time the number of the amendment, please, Representative Manos?
2023-0252H.
All right, great. All right, is there a second to that motion? All right, seconded by Representative Tur. Representative Manos, would you like to speak to the motion?
I think it improves the bill. I misspoke when I said that it changes the 60-day notice. It doesn't. It maintains the 60-day notice. But this amendment would strengthen the bill by making it simply notice to the tenants without regard to what action they might take upon receiving that notice. And it does maintain 60 days notice to the tenant. And I think that that's reasonable. I take Representative Alexander's point that a cash offer could result in a closing short of 60 days. But I think that this is reasonable in the circumstances. And I would move that the OTA ought to pass with the amendment. Thank you.
Anyone else wish to speak on this?
Mr. Chair?
Yes.
Thank you,
Representative
Mr. Chair. I think the 60-day notice sounds reasonable. And so that's why I'm going to vote OTPA.
Anyone else wish to speak? I guess I would just say, as I think we've sort of covered before, I still believe that this is not an appropriate way to go, and so I intend to vote no on this. Anyone else wish to speak? Representative Tur.
I'll just say, with the tight housing market, the idea of notice becomes that much more important because it'll take that much longer for someone to find an alternative. So, you know, with no or less than that amount of notice, it can put people in a difficult situation of housing instability.
Yes, Representative Kutar.
I do want to point out that just because somebody's buying the property doesn't mean that they can terminate the leases. They do still have to keep the leases as were on the books before, so they wouldn't be evicting the tenants that are in the property.
Anyone else wish to speak? All right, although this is I'm sorry, Representative Perez.
Cash offers on houses, apartments, whatever, are turning over in much less than 60 days now. I live in a development and they're turning over in as fast cash offers in as fast as less than 30 days. I think the 60 days really puts a hardship on the, another hardship on the landlord. And I just think that's hard. Anyone else wish to speak? All right, given the
what has happened already with regard to this bill. Even though this is an amendment, I think I'm going to do this by roll call vote. So could I ask Representative Kutop to call the roll? This will be only on the amendment first, and then we'll go to the main bill. So on Amendment 0252H, the motion is ought to pass that amendment. So would you call the roll on that?
Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman, Rep. Stapleton,
No.
Rep. Tripp,
No,
Rep. Greason.
Yes.
Clerk votes no. Rep. Perez, Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine, Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
No.
Amendment passes 11 to 8, 11 to 9, sorry.
11 to 9. Oh, so the amendment passes.
We just voted on the
We
amendment.
just voted on the amendment. All right, so now we're on to the main bill, HB 112, as just amended. Anyone want to have further discussion on the main bill? Yes, Representative Horgan.
I would just say, in terms of these buyers, you have to be a pretty audacious buyer to buy into an industry where apparently, from what I've heard, they're losing money even though they've sold they have 99.8% or whatever of their inventory rented out, and they're paying prices everybody agrees are vastly higher than what people can actually afford. So if the current rental owners are struggling even in that market, it makes me want the person who's buying these is either very brave or maybe just very brave, or there may be something suspicious about them. So I think the tenants deserve some advance notice to find out who this person is who's buying the property. Thanks.
Anyone else wish to speak on the main bill? All right, seeing none, then I would ask the clerk to call the roll. The motion before us is OTPA on House Bill 112.
I believe it's 117.
No, we haven't gotten to 117 yet. This is 112.
Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman,
No.
Rep. Stapleton,
No.
Rep. Tripp,
No,
Rep. Greason.
Yes.
Clerk votes no. Rep. Perez,
No.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
No.
Motion passes 11 to 9.
Mr. Chairman?
Yes. Yes.
Can it, I know we didn't do it at the time. Can I make a request for motion to put 379 on the consent calendar?
Oh, no, I'm glad you did that. Yes.
Okay.
Yeah.
We have to finish this first. We haven't.
Oh,
all
I
right,
thought we
yes.
were done with this.
Mr.
No,
Chair,
Just,
could I write the minority report on this bill?
sure. So who's going to write the majority report on this bill?
Representative Manos, would you?
All right, so, so hang on just 1 second, so I make some notes here. And Representative Alexander, you will write the minority?
Yes.
All right, great. All right. All right. All right, yes, I'm sorry, now Representative Turer, I said you wanted to put 279 on the consent calendar.
Correct.
Does that sound, yeah.
Three-
I don't-
379,
Anybody, 379, I'm sorry. Anybody have any objection to that? It sounds like, makes a lot of sense to me, so. All right,
Thanks.
consent. Yes.
Are we have a deadline at noon, so
Yeah,
how do we
no,
transmit
you're
the good
absolutely
news
right.
to the clerk?
So,
I'm
gonna
gonna message her now.
Mr. Chair,
yes.
the deadline would be noon today. That's probably not reasonable.
I already wrote
No, we actually, we have a draft report that was kind of.
Oh, but 379.
379, oh, yeah,
Oh,
yeah,
yes,
yeah,
I'm
yeah.
sorry.
No,
I
no,
thought we
no.
were back to this other.
No, no, no.
379, we had all agreed
We
to.
all agreed to, it's gonna be on the
That's
consent
fine.
calendar. Yeah, yeah, no, I'm not gonna impose that kind of deadline on any of the
Okay,
other stuff
okay,
that we're doing
thank
now.
you.
Yeah.
So would you like the people from now on to get the report to you when, by tomorrow night or by Friday?
Yeah, I was gonna say by Friday. If we could, by close of business on Friday, that, these reports, that seems to me to be reasonable.
Thank you.
All right, so then we'll turn to, House Bill 117. I know, there had been, some discussion about a possible amendment to that. As a, I'm not gonna go forward with that, amendment as a result of some discussions had. I would move, HB 117. Is there a second? I'm moving, ought to pass. 117 ought to pass.
I second.
Seconded by Representative Kutab, and I guess I would like to speak to this motion. This bill, as I've said at the hearing, it is designed to overturn what I think is really a very unfortunate Supreme Court decision that essentially says that if you make a contract to lease property for a year, or some other time, I suppose it could even be 5 years. But if you make a contract to lease property, when the lease is up, and it's restricted property, when the lease is up, you cannot evict the tenant. The fact that the lease is up is not enough to be able to evict the tenant. That seems to me to be very, very bad public policy. It abridges basic contract rights. And I think it also has the effect of making, again, this is another example of making housing less available, because if you say to if the law that a landlord has to comply with, which is what it is now, is if you rent this property to somebody, you're stuck with that person, not just for a year or whatever it may be. You're stuck with that person. A landlord may very well make a landlord reluctant to want to rent to somebody that the landlord sort of considers marginal, because if the law was, as it should be, I'd submit, that if you make a contract for a year or 2 years or 9 months or whatever it might be, when the contract is over, you can end the contract. Then a landlord might very well say, okay, this person, I've got some question about whether this person will be a good tenant, whether the person will have the ability to do sort of what tenants are supposed to do, that kind of thing. But it's only a year, so I'll take the chance. And at the end of the year, if it doesn't work out, then, I can just end the lease. Landlord can't do that now. And so it seems to me that there are at least some cases where that means the landlord is going to say, no, if I'm on the hook, not just for a year, but potentially forever, I'm not going to do this. So that's why I think this amendment is a reasonable change to the law. And I hope you'll support it. Thank you. Representative Macbeth.
Thank you. Thank you, Your Honor.
I'm sorry.
I need to say that I don't consider myself near the having the ability to analyze cases like you do, but I did pass out to everybody the case that you're trying to overturn, Miko versus, I can't pronounce the last name, Cassidy. I wanted to start, I've given everybody a copy. I want to start with the one opinion that was a concurring opinion by NATO that our chair mentioned when in his testimony. Even Justice NATO says that, he says the majority asserts that the mere expiration of a lease is not good cause. I disagree. I believe that the statutory language, and that's 540, it does have other good cause, is broad enough for the terminating of a tendency at the expiration of a lease. So that's the opinion, that's the one opinion that doesn't completely agree with the other four justices. And if you go back to the next page, this will give you insight to my mind. I go backwards because I think the biggest points are at the ends of the cases. But on page 6, and I've also put a thing around that, it says the time for the landlord to determine whether or not it's going to rent to a tenant is established in the beginning, when the landlord grants, offers the lease. It said the landlord is, of course, not forced into a perpetual landlord-tenant relationship. It may terminate for good cause any time that he wants by the grounds laid out in RSA 542. So I also want to say that on the next page, if you go back to 5, the court lays out some unintended consequences that I really would like everybody to think about. And instead of an ought to pass, maybe we could do a retain and look at this a little bit more. But on page 5, paragraph 3, it said if mere expiration of a lease were to constitute good cause, then tenants would be evicted arbitrarily from their homes through no fault of their own. And they would undoubtedly, at worst, become homeless as a result. And then I'm going to go to the last sentence, and it explains why it's important. The landlord has the kind of the balance of power in the beginning. They get to decide who they lease to. And then at the termination of the lease, they have to have good cause because of these type of consequences. If a tenant is for no cause of their own evicted, it says relationships with friends and neighbors may be disrupted, children may be forced into new school districts, local services and support system for elderly and disabled tenants will be lost, which would all be contrary to what the legislature intended when it passed this law. The RSA 542.2, that was in 1985. So it talks about, and I'm not going to go through the whole thing, but on the top of page 4, it outlines what this other good cause is. And several of the justices mentioned that this other good cause really is a catch-all for any legitimate business or personal reason that a landlord would have. A landlord of restricted property. And so let's remember, that's not somebody that's sharing property, renting, their home. It's not anybody that has just less than 4 units. It's really one of, a commercial landlord who I think are respectable and not, I differ with my colleague on my left regarding how he would characterize landlords. Because actually we didn't see any landlords testify in support of this, I don't believe. So anyway, I just want to say there's a lot to this. I'm not a great linear thinker like our chair, so a little bit of sausage making doesn't bother me, and I think the court's really clear why the legislature did this, and it outlines some unintended consequences. So I appreciate the chair's attempt to rectify this, but I really hope that some of you would join me and let's at least retain this and look at it. It's just what the court says is changing this to enacting this bill would eviscerate the consumer protections regarding what we have for good cause of terminating leases. So, and I see if you want to, I did highlight that as well. But anyway, thank you.
Yes, Representative Kuta.
I just wanted to reflect for the record that we did have 2 landlords that did testify in support. It was Nick Norman, who's also the chairman of the Apartment Association of New Hampshire, and David Klein, who is a landlord. I don't have on the record any tenants that were, any landlords that were opposed.
Other
Thank you for that.
So I guess just I very briefly would just say this. Can you imagine? I mean, the one of the things the majority said there was somehow it would be arbitrary to terminate a lease when it's up, That's the argument. It's arbitrary, somehow arbitrary to terminate the lease when it's up. I guess I would ask you to sort of think about this. If that's if that's the law, how about in other contexts? I mean, if you have, you lease a car for 3 years, can you say at the end of the 3 years, I have a right not to turn it in? I mean, what other contracts would we say, because maybe, you need the transportation, the lessor thinks they have a better use for it or whatever, but you need the transportation. Well, we can't allow that to happen. That's the thing I guess I just have a problem with.
And I understand, but I think the court is clear. It's not applying this to other areas. It says this area particularly when you're talking about just restricted rental properties. So that doesn't apply to commercial properties. It doesn't apply to a lot of rental properties. It just applies to these restricted rental properties. And I would say that we do look at contracts with different, like a prenuptial agreement or an antenuptial. You mean the court looks and interprets those contracts differently than it does others because it wants to make sure everybody got a fair shake. In this case, the legislature put in 542.2 to protect clients because, like it says, the landlord needs to make that decision about renting initially. They've got the balance of power up, and then at the termination of the lease, it needs to be for good cause. It can't just be arbitrary, and it's because housing is so special. And it also making people housing is a huge downshifting of costs because the municipalities are going to have to take care and pay for all the services for those folks. So I think particularly in this rental environment, it's just not smart to do anything that's going to destabilize that.
All right, Representative Horgan.
Well, first of all, I agree with my colleague to my right that this bill shouldn't be passed as is. There was a statement made by the clerk that no landlords came in to testify against the bill, but actually the New Hampshire Housing Association, Ms. Margolin from the NHHA did come in, and they have a variety of groups in there, but they do include a number of landlords because those are agencies, or I guess in some cases maybe private corporations who specialize in affordable housing. So that's a somewhat different animal than the general housing market. But there are some landlords who are in fact opposed to passing this bill as is. So thanks.
Representative Perez.
To follow up on Representative Kotab said, when Mr. Norman and Mr. Klein testified, one of the big things that I wrote down that both of them said is if they have a good client, they are a good tenant, they are not going to arbitrarily get rid of them at the end of the lease. They will then renew their lease because the cost to them to have to replace that person, they have to take that into consideration. And with all due respect, yes, they screen the person coming in, but you really don't know someone until you live with them. So you could screen all you want, but you're not going to know what that tenant's going to be like until they're actually your tenant.
Anyone else have anything to say on this bill? All right, seeing none, I would ask the clerk to call the roll. The motion is ought to pass House Bill 117.
Vice Chairman Wallace,
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
No.
Rep. Testerman. Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Kutab votes yes. Rep. Perez.
Yes.
Rep. Smith. Rep. Horrigan.
No.
Rep. DiLorenzo.
No,
Rep. Eaton. Rep. Page.
No.
Rep. Macbeth.
No.
Rep. Devine.
No.
Rep. Lanza.
No.
Rep. Manos.
No,
Rep. Turer.
No.
Chairman Lynn.
Yes.
Motion fails 9-11.
Is
So-
there
I'd like to make the motion to retain.
a second?
I'll second it.
Seconded by Representative Alexander. All right. All right, is there discussion on the motion to retain? Anyone wish to be heard on that? All right, Then I'd ask the clerk to call the roll on HB 117, motion to retain.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
No.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason.
Yes.
Clerk Kutab votes yes. Rep. Perez,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
No.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes 18-2.
Okay. All right. Representative Macbeth, do you want to write the? It was, oh, so forget about, there's no report. Good. All right. Yeah, I think, well, the problem is it's going to get
My goodness.
2:35. Oh, yeah, the vote sheet, yeah. this one, that's fine. Look, the problem is we get through 2:30. All right, yep. So, we're on, all right, we're, up to, House Bill 235, establishing, a commission to study, expansion of a landlord-tenant mediation program, and, do I understand it? Representative Alexander and/or DiLorenzo have a motion on that, is that? Amendment? Or-
Yeah.
Representative DiLorenzo, you have a motion to, amend, is that correct?
Yes.
All right, yes, please.
I'd like to make a motion to amend HB OTPA.
Yeah. All right, and that's amendment 148, is that correct?
Yes.
All right. And
I'll second
is there
that.
a second? Seconded by Representative Alexander. Representative DiLorenzo, would you like to speak to your motion?
Well, I think that this is a good bill, and I think that it needs to be explored by a study committee. I think it would be very helpful. And that's what the amendment is about.
Yes. All right, Representative Alexander, do you want to say something?
Yeah, thank you, Mr. Chair. I think this is a widely successful program from what we heard in the public hearing. I would like to see more research from Mr. Head and about more of the details surrounding the landlord-tenant mediation program. But the amendment, I think, saves the taxpayers a lot of money by turning it from a commission, which costs a lot of money, to a study committee in which a bunch of legislators with $100 a year will be able to study a widely successful program. So I'm looking forward on sitting on this subcommittee, hopefully with Representative DiLorenzo this summer. Thank you.
Anyone else have anything to say on this? All right, so first on the amendment, I think we can probably do that by voice vote. So amendment with, the question on the floor is Amendment 148H to House Bill 235. Are you ready for the question? All those in favor say aye. Aye. Any opposed? Right, so the motion carries unanimously. Now to the main motion. House Bill 235 ought to pass as amended. Anyone have any further discussion, or are we ready for the question? Oh, yes, Representative Andrews, I'm sorry.
Thank you, Mr. Chair. I am going to end up voting against this bill because there's information in front of me. Last year, this bill, formerly SB 216, was voted ought to pass on the Senate floor on a voice vote. In the Judiciary Committee, it was voted ITL 11-9. On the House floor, the vote was ITL on the voice vote, so I am going to go along.
Okay, all right. Anybody else wish to speak to the main? Yes, Representative Alexander.
Yeah, just briefly to distinguish, this is a different bill than the one that was voted out of this committee, ITL last term. That was a commission. This is just a legislative study committee, so a lot simpler and a lot less expensive. Thank you.
So what I should say, some of you may be aware, we have three special committees. One of them is a committee to deal with commissions, because we have, I think, correct me if I'm wrong, Representative Alexander, we have something like 400 commissions. Some of them haven't met
It's a
in
different
years.
committee than my committee, so I don't know. I was on a different special committee.
Some of them haven't met in years, and so the speaker, I think, very wisely wants to see if we can kind of, get a handle on this. But Representative Alexander and Representative DiLorenzo very wisely, through this amendment, have changed this, so this will be not a commission, but a committee. It will be composed only of legislators. It will be able to do its work and hopefully have a report to us by the fall, I would think. So I think it's a much different situation, and that's why I think it makes sense to do what they've proposed. At any rate, are we ready for a roll call vote on this? All right, seeing no objection, then I'd ask Representative Wallace if you could call the roll on House Bill 235 OTPA.
Vice Chair Wallace votes yes. Representative Alexander.
Yes.
Representative Andrus.
No.
Representative Testament.
Yes.
Representative Stapleton.
Yes.
Representative Tripp.
Yes.
Representative Greason.
Yes.
Representative Kutab. Representative Perez.
Yes.
Representative Smith.
Yes.
Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Eaton.
Yes.
Representative Page.
Yes.
Representative Macbeth.
Yes.
Representative Devine.
Yes.
Representative Lanza.
Yes.
Representative Manos.
Yes.
Representative Turer.
Yes.
Chairman Lynn.
Yes.
Votes 18, 1, and 1.
Yes.
Representative Andrus doesn't object. I would think this could go on the consent calendar. I don't object.
Consent, okay. Consent and, second. Consent and, Representative DiLorenzo or Representative Alex, who will write the report? Representative DiLorenzo?
Yes, I would like to.
Great, certainly, thank you.
And that's due on Friday, correct?
Due on Friday, yes, please.
Thank you.
Hang on one second. All right, then let's turn to House Bill 261, authorizing residential tenants to terminate their lease in instances of domestic violence or following a disabling incident or accident. The chair recognizes Representative Perez for a motion.
Thank you. I would like to make a motion to ITL this bill. Thank
All
you.
right, is there a second?
I second the motion.
All right, motion has been moved and seconded. Representative Perez, would you like to speak to your motion?
Yes, the concern was a lot of vagueness in this. As far as disability, how do we find, is it a short-term disability? Is it a long-term disability? The term no longer enjoyable seemed extremely vague. There are other things as far as it terminating with domestic violence. Are we terminating because the person is the domestic violence person, or the person is being violenced against? It just was way too vague in the way that it was.
All right. Anybody else wish to be heard on? Yes.
I'm not sure, I think Representative Devine might want to be there.
Oh, yes, Representative Devine.
Yeah, I'd like to make there's an amendment circulating that would make the bill exclusive to domestic violence. I'd like to introduce that.
No,
Can't do it?
Just-
Okay.
We can only talk about it.
Okay,
Talk
can
about
only talk about it. It basically just takes out, keeps everything the same except for it removes the disabling accident part. Lines 15 through 25, just to make it a little bit simpler. And I think there seemed to be a lot more sympathy or whatever towards victims of domestic violence. And there's not really, it enables them to get out of a difficult situation. And this bill would allow for that, where right now there's nothing that is available to them to actually get out of a lease if they have to, if their life is threatened.
Yes, Representative Perez.
I apologize. I'm new at this. One of the things I forgot to bring up with this bill as well is, so if we have this for both disability and domestic violence, why is that any different than me terminating my lease because I have an issue, I lost my job? It can open the can of worms, as I say, or Pandora's box to adding additional things on to this type of legislation.
So, yes, Representative Turer.
Yeah, just sort of in response to that, and also sort of in support of the amendment, potential amendment. I think the reason for taking the second part out, the disability, is these are very different situations that are sort of rolled into the same piece of legislation, sort of inappropriately. So I think it's much cleaner to focus on domestic violence, and the state already goes to great lengths to protect the location, whereabouts of victims of domestic violence and in other situations, and the presence of their known whereabouts is an immediate hardship to the person who's suffering. So I think passing this would provide a necessary relief for that group without sort of muddying the waters.
Yes, Representative Macbeth.
Thank you. So just to speak to the amendment and actually my colleagues' comments regarding domestic violence, I think the thing that carve out for domestic violence, why it's significant, not only do sometimes victims need to keep their residence secret, but in many instances, because the domestic violence statute requires it be an intimate partner, it's somebody that you are living with. So your lease needs to be terminated both by you and, so it would be the victim and the defendant because they can no longer afford to live there probably. So I think that DV is it has a special difference. There may be other, groups as well, but I think it really would be, I hope that people will listen and consider the amendment by our colleague.
Anyone else wish to be? Yes, Representative Greason.
Thank you, Mr. Chair. Addressing the issue of domestic violence, a landlord does not want some creep coming around the property and causing havoc for any of his tenants or her tenants. And so if there is a restraining order in place, there is an issue of if the tenant that is being harassed in whatever way needs to be able to get out of the lease because the situation is escalating or could potentially escalate, you can avoid the midnight move outs that the landlords have testified that becomes very problematic because at some point in time the victim of this abuse is going to say, I've just got to get out of here, and so they just leave in the middle of the night. You also can eliminate the by being able to move out and the privacy rights being protected, you prevent the potential abuser from being able to find out where that person has moved, the victim has moved on to. So I think you can actually prevent a lot of issues by allowing the termination of a lease because of this situation, avoiding those midnight move outs, and still permitting it to take place. I think an amendment to that, I don't like I think trying to cover both the bill as it is originally written, I think is problematic, and I would ITL the original bill. But to amend it to just deal with the domestic violence and allow for the termination in these instances, I think is prudent.
Anyone else wish to be heard? So I guess my take on this is I'm going to vote in favor of ITL because again, this is another example. So now we've made, if we pass this, now we've sort of told the landlords, you have another thing to be worried about. You have to run the risk that if there's a domestic violence thing, you potentially will have to terminate the lease, give back the security deposit, I guess, in those situations, because it will be a proper termination of the lease. And so this is another sort of, cloud on the horizon. So what are landlords going to do? Well, some of them presumably are going to get out of the business of being landlords. But more likely what they're going to do is say, well, I may have this risk. So what will I do? Well, I'll raise the rent. That's what I'll do. That will cover, to sort of cover for the potential increase in the risk. I don't think that that's what we want to do particularly at this time. So I intend to vote ITL on 261. Anyone else wish to be heard? All right. Are we ready for the question then? I would ask the clerk to call the roll, and the motion is ITL on House Bill 261.
Vice Chairman Wallace,
Yes.
Rep Alexander,
Yes.
Rep Andrews,
Yes.
Rep Testerman, Rep Stapleton,
Yes.
Rep Tripp,
Yes.
Rep Greason,
Yes.
Clerk Hutab votes yes. Rep Perez,
Yes.
Rep Smith, Rep Horrigan,
No.
Rep DiLorenzo,
No.
Rep Eaton, Rep Eaton,
No.
Rep Page,
No.
Rep Macbeth,
No.
Rep Devine,
No.
Rep Lanza,
No.
Rep Manos,
No.
Rep Turer,
No.
Chairman Lynn.
Yes.
Motion fails in a tie 10 to 10.
Can we offer another motion?
Yes.
So,
I'd like to motion to proceed with this amendment to, the number is 0351H. Pretty much everybody should have it.
That's an OTPA amendment, motion.
Yes,
I'm sorry, could you give me the number one more time, please?
would be 0351H.
H, okay. I'm going to call a
To House Bill
recess for
261.
a few minutes to, I think I can still call a motion. I think I can still call a recess. So I'm going to call a recess for a couple of minutes. All right.
Mr. Chair,
You can't do that during the vote. before we get back to taking any votes, I would ask that there are actually two different amendments for this bill. And the one that we're presently discussing only addresses the domestic violence part of it, of the original bill. Okay? The other amendment deals with both portions of the original bill. The problem is I like the wording of the not yet mentioned amendment of the domestic violence piece of it, but I don't like the disability portion of that amendment. So I would ask if my colleagues would actually vote no on the current vote, to vote it down so that we can move to retain this, so we can mesh the amendments and have one workable amendment. Because otherwise I have to vote down both amendments, and I think that misses the issue.
So I think I guess, well, I mean, I guess it's sort of up to the people that support the amendment, whether they want to, I mean, I guess I would say, in fairness to everyone, I want everyone to, at least speaking for myself, and I don't know about my colleagues, but speaking for myself, I want to make sure that everybody understands that even that I would oppose whichever version of the amendment is, I would still oppose it. So I don't want anybody to think I don't want anybody to vote no on the assumption that there might be some change in heart on the part of others of us other than Representative Greason. So if you vote no, it's a no vote. I guess that's the best way I can put it.
Mr. Chair, could I just clarify? So
Yes, certainly.
the amendment that we're talking about now is 351H, and that's the amendment that removes the last section of the bill dealing generally with disability. Is that correct?
Yes,
And then the amendment that Representative Greason is talking about is 420, and that's the one that makes a number of changes in each section. Is that correct?
420 is the other amendment.
Right, okay. I just wanted to know who was on first.
And can I clarify for a second? And what Representative Greason was suggesting is to combine the domestic violence added to 420 and add that to 351. Is that correct? Do I understand that? Is that?
Okay, Representative Tur.
Yeah, I mean, I in terms of the retain question, I still sort of feel like these are separate and would best be dealt with separately. So I still like the idea of the narrower domestic violence only version. But I'm wondering if Representative Greason could say a bit more about what is problematic in that version of the amendment.
The other amendment, 0420, addresses the landlord may charge the tenant an early termination fee not to exceed 50% of the monthly rental amount. This fee shall be prorated to be 50% of the monthly rental amount if the initial tenant rental agreement began less than 6 months prior to termination, and 25% of the rental amount if the tenant lived in the property 6 months or more. So it allows the landlord to recover some of those fees that would be experienced in an early termination that were concerns from some on this panel. But otherwise, it pretty much leaves everything else the same. We could do a side-by-side on it. But I like the idea of the landlord being protected as well, and just that recouping of the cost of a early termination, but while still protecting the victims of domestic violence.
Appreciate the clarification. Thanks.
So Representative Manos.
Thank you, Mr. Chair. On other occasions where we have been close but language needed to be tweaked, we basically held consideration over until we could tweak it and then present it. And I'm wondering whether this would be another appropriate case to do that. And I would be more than happy to work with Representative Greason and Representative Devine to do that.
Yeah, I think that makes sense. Yeah, so anybody have any other, anything that anybody else wants to say on this? I think that probably does make sense to just, we'll just, hold off. We won't finish the executing on this until, next time or whatever, and then, you can, Representative Greason, you can work with, Representative Devine or Representative Tur or whatever, or whoever really, on trying to come up with language that, that makes sense. Is that, anybody have any problem if we do that?
What is the reporting deadline on this?
This is not an early bill, so I believe, yeah, let me, hang on, I'm pretty sure.
So we
it's-
go till March?
I think we can go to March, yeah. It's not, this is not an early bill, so March 16th, so we have time. So probably what I would do is put this on
The first,
the exec, our next exec session, which will be after, where we will do the exec session on many of the abortion bills and that kind of thing. We'll probably do this one at that time too.
okay,
Right? That makes sense to
that
everybody?
makes sense. And we know who's going to get that amendment together. Representative Greason, Representative Devine,
Greason and Devine and Manos? Okay, sure.
and of course Representative Reed, who's not on the committee, but is
That's
very
right,
present.
Right. All right. Okay. So, yeah, lunch, all right. All right, so, this is 1:15. I suspect that some people are getting hungry. Should we, take a recess? Anybody have an objection if we take a recess for about, 45 minutes or so? How about
Back at 1:30?
back at 1:30?
Sounds
That makes
good to
sense?
me.
All right, we are in recess.
Not bad. Oh, sorry.
I guess, before we move on to House Bill 283, it's my understanding from, we just had this discussion yesterday at the chairs meeting. In committee, any member can file a motion to reconsider, whether you're on the winning side or the losing side. So based upon my discussion with Representative Andrus, it's my understanding that she may have had, and I'll obviously ask her to speak to it, but it's my understanding that she may have had a misunderstanding as to the purpose of House Bill 117. And so on the basis of that, I'm going to ask for I'm going to move to reconsider that. I want to emphasize this. I hope that the body will agree to reconsider it. I completely understand and would expect that if we reconsider and then we get to the motion on the merits, I suspect it will very likely be a 10-10 vote, and I completely understand that. So I just want to emphasize, I'm asking for reconsideration only so that we may go from retain, which it is now, to a 10-10 vote of no recommendation. And as I say, because I believe Representative Andrus may have misunderstood what the bill accomplished. So Representative.
Mr. Chair, I would be happy to move reconsideration as a courtesy to my colleague.
Well, I very much appreciate that. So I guess Representative Andrus, did you?
Yeah, the only thing I wanted to say, I want to apologize. I misunderstood what some of the bill, what it was going to happen. And so now I understand it fully, and I apologize that we're going to have to vote again. Thank you.
So I would move, and yes, I do have a second. Representative Smith is second. So,
Thought I moved.
yes, of course.
Are we just taking one reconsideration vote on both motions, or do you have to take separate votes on the retained motion and then backtrack and reconsider the other vote?
So I think, I guess the motion for reconsideration would be on the motion to retain. If that passes, then we've reconsidered the motion then the motion to retain is up for a vote. I suppose we then have to vote on that. If that fails, then we would be back on to the motion of, I believe, of OTP. Is that your understanding, Representative Smith?
Well, whatever, if retain fails,
Right.
then the bill would be open to
Open to further
another
motion.
motion.
Right. Sure.
Whatever that was.
All right, so the motion to reconsider has been made and seconded, and could I ask I think we need a roll call on this, so could I ask the clerk this is a motion for reconsideration on House Bill 117. So could I ask the clerk to call the roll on that, please?
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Hutab votes yes. Rep. Perez,
Yes.
Rep. Smith,
Yes.
Rep. Corrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton, Rep. Page, Rep. Macbeth,
No.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes. And I guess I want to thank my colleagues on both sides of the aisle for that, for your vote on this. I completely understand that on the merits, you may have a different view from some of us, but I very much appreciate the courtesy of your vote on this. All right. What was the total?
So now it's
The total vote on the motion to reconsider was 19-1.
All right, so now, the motion to retain is what's on the floor. Well, no, I'm sorry, the motion to retain, we've reconsidered that. And now, is it
I think it's retained on the floor now, don't you have to?
Retain, we have, so do we want to,
I think you have,
no, I
Dan,
think,
you have to vote on retain first. and-
fails, and you can go to any other motion.
okay, all right, sorry. So, the motion to retain is what's on the floor, and I guess I would, urge that that motion, be rejected so that we can have another motion, which, just to sort of play this out, if that motion, if we vacate the retain, then I would move ought to pass. I suspect that that will fail on a 10 to
Well,
10
why don't you
vote.
do one at a time?
All right, that's fine, that's fine. All right, so on the motion, on the reconsideration of the motion to retain, I think we're ready for a roll call vote, and I would urge people to vote, not to retain the bill.
We just voted to reconsider, right? And now are we voting to OTP? I'm confused.
No, you
No.
have to vote to retain.
motion is
The
retained.
motion on the floor would be retained.
Right, and my position would be we should vote no on retaining it, so that
Correct.
retain will fail, and then it will be open to further motion.
Now, the only comment I want to make on that, Mr. Chairman, is unless I'm wrong, you have only one vote.
I have only one vote. Yes,
Right.
indeed, I do.
Okay.
I do. I have only one vote. All right.
Okay, so for HB 117 on the motion to retain, Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman, Rep. Stapleton,
No.
Rep. Tripp,
No.
Rep. Greason,
No.
Clerk Kutab votes no. Rep. Perez,
No.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
No.
Tie 10 to 10.
So, am I understanding? I guess I'm asking you to. Has failed, and so now we're
The floor is open
to another.
any other motion.
Thank you. No, I appreciate that. I thought that was right, but I appreciate your guidance on this. So, I would now we're sort of back, and I would make a motion of ought to pass on 117, and I won't, in the interest of saving time, I would say the same things I said before of why I think it ought to pass, and that's all I have to say. Somebody seconding the motion of ought to pass, Representative Wallace, seconds.
There's no amendment on this one.
There's no amendment to that. So anybody wish to speak further? All right, I think we're then ready for a roll call vote on 117 ought to pass.
It could be very wrong here, but I think the semantics are wrong. The motion was to reconsider retain. That motion failed. So retain would stand.
No, if you voted yes to reconsider, let's voted no on retain.
And it was tied.
Right, so that means that means retained fails.
It went back to the original. It didn't overturn under reconsideration, so the underlying motion. I think that
Yeah,
you might want to drop the line to the front.
That's, you may be right. All right, sorry, folks, we're gonna take we're gonna take a brief recess while I get guys from the clerk.
So, we reconsider.
Are we playing hockey?
For people who are in the audience, I just called to get guidance from the clerk on this because I thought Representative Eaton had a very valid point. But what the clerk explains to me, we never had these parliamentary procedure in Supreme Court, I have to say. Right. So what the clerk explained to me is we voted to reconsider the motion to retain, and we said we wanted to do that. We approved that motion. So that means that what is before the committee then is, should we retain the bill? And we had a tie vote on that, which means that motion to retain fails. So now we are up for a vote on other motions, and I had made the motion of ought to pass. So that's the issue before us now. I believe, as Representative Smith was saying, is if we vote on this motion of ought to pass, if it fails and there's another motion, we would vote on that. If that fails, then I think motion to retain would then be in order again.
We could go back, there has to be an intervening motion. There is an intervening motion because we're now voting ought to pass.
Right.
And who knows, it might pass. Who can tell?
Right. All right. So no. So anyway, thank you all for your guidance on this. I appreciate it. So the motion on the floor is ought to pass on House Bill 117, and I would ask the clerk to please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason.
Yes.
Clerk Kutab votes yes. Rep. Perez,
Yes,
Rep. Smith, Rep. Horrigan,
No.
Rep. DiLorenzo,
No?
Rep. Eaton,
No.
Rep. Page,
No.
Rep. Macbeth,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Chairman Lynn.
Yes.
Tie 10-10.
So that motion fails. Is there another motion?
ITL. Retain.
wait, but we already had a retained motion.
Well, we can vote again on.
With there has to be
With
an
an
intervening motion, which there was. Representative Lynn. there's
Oh,
your
I'm sorry. Oh, I'm sorry. Yes, of
I
course.
just wanted to ask a question. What will the result be if the motion to retain fails?
To tie vote
Then-
and goes without recommendation.
Well, no, you know what, there could be, I mean, no, then I think correct me if I'm wrong, I think there could then be another motion of ITL. And we would vote on that, and if that also fails, then it would go without recommendation.
Thank you for the clarification.
So, we have a motion, to retain, and that was seconded? The motion to retain?
Haven't heard a second yet.
Oh, I'm sorry, we have a second on the motion to retain. Not seeing okay, seconded by Representative Devine. Representative Beth, do you wish to say, I mean, are you happy to say
I
anything?
think I've said what I.
Okay, all right. So, the motion's been made and seconded, to retain, House Bill 117, and are we ready, for the vote? Yes, we are. So I'd ask the clerk to please call the roll.
Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman,
No.
Rep. Stapleton,
No.
Rep. Tripp,
No.
Rep. Greason.
No.
Clerk Kutab votes no. Rep. Perez,
no,
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes?
Rep. Eaton,
Yes.
Rep. Page, Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
No.
Motion fails 10-10.
Yes. Representative, Chair recognizes Representative Smith.
Second.
All right, anyone wish to speak further on this, on the ITL motion?
I would just like to make
Yes.
one comment, and for those people who didn't think it was fun to be in the legislature, this is an example of how much fun it can be.
All right, yeah, Representative Beth.
I guess I just want to speak again. I'm sorry that we are reconsidering this bill, but I just want to remind everybody that this has been a policy for over 30 years, almost 40 years and or more, since 1985, and the Supreme Court has been clear. This voting for 117 eviscerates the consumer protections for tenants, that they can be arbitrarily evicted without just cause. And there's no need to do this. Landlords have other tools, which the case clearly stated. It has for good cause, which is for any legitimate business or personal reason. So I hope that people will reconsider and not let this bill go forward.
All right, I guess I just have to say respectfully, I just, for the reasons I said before, I just disagree. I mean, as I tried to point out at the hearing, it seems to me that this really sort of encourages, if you, I mean, as I said at the time, is this, if this bill fails, is this like the end of the world? Landlords are going to be in a terrible situation? No, but what it seems to me, what having the law the way it is now encourages landlords to come up with some other reason. In other words, instead of the lease is just over, and this is not a particularly good tenant, but I don't want to have to go through the hassle of saying, you're a drug dealer, or try to prove that in court or whatever. So the landlord raises the rent, whereas maybe they wouldn't raise the rent, and to an amount that they know the tenant can't pay, and then the tenant is evicted on that way. Does it really make sense to allow that a landlord has to kind of go through those machinations? Maybe to some extent, you might say dishonestly, because if they had the power that they should have under the law, you made a contract for a year, it's over. When a year's up, it's over. We wouldn't have that. So that's why I think this just kind of is bad public policy. Anyway, I've said my piece.
The other thing this is, if I know I cannot get rid of somebody at the end, I'll just raise the rent. Whatever days you have to give them, then I'm raising the rent and they'll be gone that way. This makes it a lot easier if they don't want to get rid of them. It makes sense.
Anyway, so I guess, are we ready for the vote? All right, I guess we are. So this is on the ITL motion, and I'd ask the clerk to call the roll, please.
Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman,
No.
Rep. Stapleton,
No.
Rep. Tripp,
No.
Rep. Greason,
No.
Clerk Kutab, no. Rep. Perez,
No,
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
No.
Motion fails 10-10.
All right. So, all right. Well,
Mr. Chair,
again, yes.
could I ask for us to reconsider the vote to reconsider HB 117?
Yeah. Can we have more than one motion to reconsider?
Asking to reconsider whether or not the committee reconsiders
Reconsiders,
that
right.
vote, the initial vote.
I'm not sure if you can or not, but I'm not in, you all gave us the courtesy of voting to reconsider, so I'm not going to say, no, we can't do that. So there's a motion to reconsider. Is there a second?
Mr. Chair, I don't think you can reconsider a vote. Pardon? I don't think we can reconsider a reconsideration.
I'm not sure, but I'm listening to Representative Alexander, who is sometimes right.
Right.
And I don't, I mean, you could go and call Paul again, but I don't think so.
You know what, can
mean,
I-
I think we have a few choices, not any of them is a particularly good choice. And, I mean, we could go back to retain, and the bill could be protected that way, if you would like that. Or we could agree to send it to the floor without recommendation. I personally have problems with that because overwhelmingly our votes have not succeeded in supporting OTP, and that would be the first motion if it goes to the floor without a recommendation. So we would have to either support that on the floor or argue against it. And those of us who believe that the important work of the legislature is done in committee, I know I would personally not be comfortable wanting to argue against what would be the first vote, which would be ought to pass. But the committee hasn't been able to support ought to pass. And that's why I think in the best interests of those who support the bill and those who oppose the bill, I would again suggest that we consider retain, where that gives us the opportunity to see if we could come to some agreement. Maybe we can't, but with time, we might be able to come to some agreement, and believing that it's always best to get to yes, I would again suggest that we consider the possibility of retaining the bill and giving us time to see if we can find out if there is any way to get yes. Maybe the answer will be no, Mr. Chair, but I think it's worth trying. May I?
So, yes, Representative Kutab.
If Representative Smith thinks that there may be a way to possibly compromise on this, would it be possible that we could recess this one until another future hearing rather than retain it? Because it's not an early bill, it's not due until is it 3/16? So that we could try and reach some sort of a compromise by the end of this month. I think when the next session was the 24th or 25th we were aiming for. For then, might that be something to consider? Rep Smith, if you're thinking that we may be able to, do you think we could reach a compromise in a timely way?
Respect the clerk's comment, but Mr. Chair, I think that we've indicated up until now that we're really evenly divided. We have a number of other important bills to get through today. Next week on Tuesday, we have a session, and on Wednesday and Thursday, we have two very difficult days of hearings, and the following week, we have at least two session days. Well, we have at least one and probably two session days. I think we have a lot on our plate, and it might be time to take a little break from this and let us get back to it a few months from now when we can be more relaxed. So my suggestion is that I don't think we can I would not think we can come up with a successful solution in the next couple of weeks.
All right. Yes, Representative Horgan.
Of course, I'm bending the rules a little bit by speculating about what some other body might do, but the full House does have a track record of tabling many bills, most of which are ITL bills that they worry might not be ITL. But so that's certainly a distinct possibility if this ends up on the floor with an ITL that, like, someone, I'm not going to speculate who, will jump in with a tabling motion before the ITL can be voted on, in which case the bill dies on the table and then can be reintroduced. Identical bill or a similar bill can be reintroduced during the pre-2024 filing period. So
I appreciate that. So you know what, can I add, so oh, I'm sorry, somebody else wish to speak? Oh, yes, Representative Tur, please.
Just one quick comment in support of this idea. I think there's two things that I see with this that are problematic. One of them is sort of housing continuity, which is kind of the big piece, and then the other one is the question of discrimination in the underlying reason for terminating someone's lease, because most of what I've heard for the reasoning for this is bad tenant without really a definition of what that is and sort of an open-ended. So I do see maybe that there is some room in that regard for closing that up a bit. So that would be one reason in favor.
Representative Alexander.
Thank you, Mr. Chair. Last week, we sent a bill to the floor without recommendation that all 10 Republicans voted against. That will go ought to pass. I mean, I understand what Representative Smith is saying, but that's just the unfortunate result of having a 10-10 committee is there are going to be some bills that go to the floor without recommendation, and the first motion might not be the one that we necessarily support as a committee, but that's just how House rules are. So I would just say that let's exhaust all motions and then send this to the floor without recommendation.
So you know what, I guess what as I said, I very much appreciate the fact that our colleagues who disagree with us on the merits of this permitted the motion for reconsideration. So I don't know, Representative Macbeth, whether we can properly have this second motion for reconsideration or not, but I'm willing to say I'm willing to, not press that point and say let's do it. But I guess what I would say is before we have that vote, would it make sense to have just sort of an informal show? Because if that motion is also, if your motion to reconsider is also going to fail 10-10, I'm not sure what the purpose is. But I'm willing.
The motion wouldn't be to reconsider, the motion would be to retain.
No, she's moved to reconsider the reconsideration. No, it would be the motion to reconsider the reconsideration that would fail. So that's the, yes.
That's right.
Why don't we, maybe we could delay, we could talk to Paul about the possibilities, the clerk.
Reconsideration is not
I'm asking for
Correct.
Reconsideration is not.
Reconsideration is not
Okay.
reconsideration.
All right.
Go on in perpetuity.
Right. All right. So I think it sounds like what I'm hearing from people on both sides of the aisle, so to speak, is that we can't really reconsider the reconsideration.
But we
So-
can go, since there's been an intervening motion, we can go back to retain.
Yes, we could go back to retain. So I guess I appreciate what you say, Representative Smith. I guess I'm kind of more of a mind to have it go to the floor. I understand what you're saying, but I would be more inclined to do that. But I certainly am not. If you make a motion to retain now and it's seconded, then we'll have a vote on that, and maybe people may agree with your position. It's certainly not an unreasonable position.
Mr. Chair, I'm looking at the time. It's 2:10. I would assume that I am not the only one who would like us to go through all the bills today and not have to come back tomorrow.
Yes, absolutely.
Now, I hope that doesn't speak poorly of my commitment to my legislative responsibilities. But I would consider the possibility of taking a straw vote, given, we've gone back and forth and back and forth. We've tried to respect the different views.
Yep.
I believe that if we retain the bill, we might end up in a few months with a way to get support for this bill and get it through with some changes, probably minor. If that is not a chance that people want to take, that's fine. I understand that. So let's see if you would consider it. How many people would now consider, given the way we've been divided, would consider retaining the bill to see if we could more positively address it. And if that fails in a straw vote, then I would say let's just stop then and let it go to the floor with that recommendation.
Yes, Representative Kutab.
I just want to understand correctly because I am newer. So if this went to the floor with no recommendation and it didn't pass, at that point, if something new was entered for 2024 that was different than what's there now, would that be allowed because it's different? So could we essentially just put it to the floor, see what happens? If it doesn't work out, then we can try and work something out for next time without having to keep just re-voting on this now?
I think it would, I mean, I think it would depend on how different it is. If it, there could be a,
Well,
yeah, it'd have to
if
be
it goes the
substantive.
floor, we don't know. The first motion, when it goes to the floor, is going to be ought to pass. And, there will be arguments in favor of ought to pass, and there will be arguments against ought to pass. And then a vote will be taken. And we don't know what the vote will be. If the vote is ought to pass, then it goes to the Senate. If the vote is, if that vote fails, then the next vote would be ITL, and if that passes, it wouldn't go to the Senate. Somewhere along there, anyone could argue for the bill to be tabled, and then the bill could be brought off the table at some point between now and the end of the session. And that would be done by people who have counted who's present and who's not present, because they'll take a guess as to whether the people in favor will take a guess as to whether they're better off tabling or better off going ahead with the vote. And that can't be decided in advance. It has to be decided when we see who shows up. And so there are lots of, there's still lots of opportunities. I would hope that the committee would want to keep control of the bill, because obviously a lot of people care about it positively and negatively. And by retaining it, we keep control. We don't give it to the House to control. But if you want to give it to the House, then what will happen is it goes to the floor with no recommendation, with the first motion of ought to pass.
So I guess, I appreciate the points that you make, Representative Smith, and some of them I might agree with. But on balance, I guess I would tend to say I would rather have it go to the floor and just have the votes on it. And I understand that it would be ought to pass. So, but if you make a motion to retain and it's seconded, then we will take a vote on that for sure.
And you don't want to try a straw vote just to avoid.
Well, so, no, that's a good point. So let me just ask, assuming that the motion to retain was made and seconded, could I just ask for a show of hands who would vote to support that? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So it would be 10 to 10, and that would fail. So thank you. So I think we've had a good discussion on this, and I appreciate, as I say, everyone's having this discussion. All right.
And there will be a minority report. I hope Representative McBeth would be willing to write it, but if not, somebody else will.
I will write that. Thank you.
All right. So I'll write the majority on this, and Representative McBeth will write the.
And Mr. Chair, just to clarify, it's
Yeah.
a statement in support of ought to pass,
Of ought
not
to
a
pass.
majority report, because we don't. have a
Right. I'm
majority.
sorry. Yes. Yeah. Right. Exactly. Macbeth. Okay.
And our motion then on the floor, I believe, Representative McBeth would be IPL.
Right. P and ITL. Okay. All right. So I think we now turn to House Bill 283, and I recognize Representative Tripp for a motion.
I move inexpedient to legislate.
Is there a second? Representative Stapleton? Right? Representative Tripp, would you like to discuss your motion?
Yes. This bill deals with application fees charged to a potential tenant in the process of vetting the tenant's ability or the tenant's background. I have two problems with this bill. First off, it calls out that there can be no application fee in excess of $35. The issue I have here is that should the initial vetting return a bad indication, there'll be additional fees due to additional vetting carried out by the landlord. The second issue is that it says that fees for the rental application process shall not exceed $250. The issue here is in times of inflation like this, the vetting fees will undoubtedly increase, and anything over $250 would be at the expense of the landlord. These are the two reasons I have to ask for an ITL.
Yes, Representative Page.
Thank you, Mr. Chair. I'll be voting against the motion ITL. I do have an amendment that's gone around that I think addresses Representative Tripp's concerns. It would not have a cap or speak to any fee per se. It would allow the landlord to charge whatever fee he or she would deem necessary, and then the only difference would be that the amendment would provide that the person who actually takes the place is charged the fee. So I think that was something that came up in hearing. I think this is going back to what we've heard. We've had a thread of comments on landlord-tenant issues and talking about, I think, ultimately fairness to the parties involved. I think this is an amendment that addresses that issue of fairness. We did hear testimony during hearing about how prohibitive it can be for a prospective tenant to fork over $40-50 for a shot at 10 apartments that they have maybe won't get. So I think that's a lot of money for anybody, and it's certainly a lot of money for folks who are trying to find a place to live. I'm skeptical that this would impact any sort of supply to the extent that this is a supply. It could be a supply question. I'm skeptical that it would impact that. I mean, we've heard round and round and round that the supply is effectively zero. I'm not an economist, but I'm not sure it could get much worse. So hopefully the amendment addresses the questions that Representative Tripp had raised. Thank you.
Any other comments from anyone? I'm sort of back to, I intend to support the ITL, and I'm sort of back to what we said before, what a landlord will, if this comes into effect, what a landlord will figure in the calculations is that here's, now I've been limited in this, the rent goes up. So we'll have higher rents, and I don't see how that's really in anybody's interest. Anyway, I've said my piece. Other people, yes, Representative Tur.
Yeah, I just wanted to say, and again, I know the amendment's not offered yet, but if I'm looking at the right one here, then, it's very much of a rewrite of the original bill, and it seems like a really great bipartisan compromise that takes into account all the testimony that we got in terms of all the various problems without placing any hard caps on anything. It avoids all the churning and such that was described in terms of all the various fees that are collected, and sometimes collected potentially without even the intent of renting if it's that type of market. So I would hope that we would get to a point where we can hear a choice on that amendment.
All right. Anyone else wish to be heard? Yes, Representative Perez.
You all have heard that there is pricing wars on houses being built. Well, there are actually pricing wars on rentals, and this would forbid a landlord from taking, you and I both apply, we both passed the background check, you did it first, but I'm gonna offer him $75 more a month. Landlord should have the option to do this. That takes that away.
All right, anyone else wish to be heard on 283? All right, and then the motion before us is on ITL, on House Bill 283, and I would ask the clerk to please call the roll.
Vice Chairman Wallace?
Yes.
Rep. Alexander?
Yes.
Rep. Andrews?
Yes.
Rep. Testerman?
Yes.
Rep. Stapleton?
Yes.
Rep. Tripp?
Yes.
Rep. Greason?
Yes.
Clerk Kutab votes yes. Rep. Perez?
Yes.
Rep. Smith? Rep. Horrigan?
No.
Rep. DiLorenzo?
No.
Rep. Eaton? Rep. Page?
No.
Rep. Macbeth?
No.
Rep. Devine?
No.
Rep. Lanza?
No.
Rep. Manos?
No.
Rep. Turer?
No.
Chairman Lynn?
Yes.
Motion fails 10 to 10.
There, another motion?
Yes, could I, Mr. Chair?
Yes,
I would make a motion to OTP with an amendment numbered 422 that's been passed around.
422. Oh, is that the one, Representative Greason, that I gave, did I give you that? Is that the one? Oh, so you have it, okay, all right.
Yeah.
22.
Representative Page, do you have extra copies of that? I don't see that in front of me.
I believe Representative Reed had passed those around earlier.
No, I've seen it, so I've seen it, but it sounds like a lot of other people have not, so. Anybody else need a cop?
I apologize, I thought that went around. I'm happy to give you my copy.
I see it. I was looking for your name on the top of
I'm
it.
sorry,
I don't
yes,
see
it's-
it, so
it's
that's
marked
why I was looking for another one.
Sorry. It's 422. Representative Reed is the title author.
So, all right, so do you want to speak to the motion, Representative?
Very
Page?
briefly, I mean, I've
Sure.
already mentioned, what the amendment does. It allows, it lifts any sort of caps. It does rewrite the bill in that sense. So it addresses the questions that I think Representative Tripp had raised. I think fundamentally it resolves some of the fairness questions, I think, in favor of the tenant. I do think that Representative Chair Lynn, certainly raises a question about, legitimate question about whether or not that the higher rent might be baked in. That may have a function of sort of self-selecting. It may actually be something that works to the landlord's favor, in the sense that if folks see the rent or whatever it is, that may self-select who's applying for that. So it may whittle the field a little bit. But it's a pretty straightforward bipartisan amendment, and I'm hoping that the committee will support it. Thank you.
All right. Yes, Representative Smith.
Is this the amendment that was submitted by Representatives Reed, Greason, and Capano?
Yes.
Okay, just checking. Was the right? Thank you.
All right. Anyone else wish to be heard? All right, so this is a vote on the amendment. Do we need to have a, yes, Representative Stapleton?
Relative to the amendment, I have a problem with the section that says if a landlord collects a rental application fee from a prospective tenant, the landlord shall be obligated to rent the unit to the tenant, provided it passes criminal background and credit check. It leaves no other reason for a rejection. I've been asked to be a referral for people who wanted to rent properties. And what if, for instance, the referrals report, well, he's trashed 2 other places? Or there's some other thing. I mean, you can come up with any number of things that could be valid, some could be invalid, but it basically closes out the option to reject on some other cause, legitimate or otherwise. And I think that's an imposition against the freedom that the landlord should have commercially.
Yes, Representative Greason.
Thank you, Mr. Chair. And in response to that, the last sentence of the amendment says nothing in this paragraph shall require the landlord to conduct a criminal background check and credit check or prohibit the landlord from renting to an applicant who does not pass the criminal background and credit check. So right there, if they've trashed 2 places, that's grounds for saying no.
Anyone else wish to be heard? All right, so, I'm sorry. Yes, Representative Stapleton.
I would still say that excludes, rejection on other cause. And it denies the landlord the freedom or the ability to investigate and act on other causes for declining the rent.
I mean, I guess I'm sort of back to the same thing I said. The more you sort of make things risky for the landlord, I now have this. I have to worry about, have I complied with this, or am I likely to get sued or something like that because I've violated this new they're going to factor that risk into the rent, it seems to me, and it's going to just be. This is not going to make housing more available. I think it's going to make it less available. But anyway, yeah.
So, Rep. Page had moved the adoption of the amendment. We didn't have and asked for OTPA. We didn't have somebody to second that.
I thought we actually did, but maybe I'm sorry if I. So is there a second? Representative Smith seconds. Okay. All right. All right. So, anybody else have anything to say before we vote on the amendment? All right. So then we'll have a roll call vote on the amendment that was offered by Representative Greason, Kutab, and Reed. I'm sorry, Reed. And I'll ask the clerk to call the roll.
Well,
That's what we're voting on now. Yeah, we're voting on whether to adopt the amendment.
Can we just show of hands?
Mr.
Oh.
Chair, can we get a roll call?
There's been a request for a roll call. I'm going to do that. All
Vice Chairman Wallace. Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk Kutab votes no. Rep. Perez.
No.
Rep. Smith. Rep. Horrigan.
No.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
No.
Motion fails. Wait. 10-10.
All right. So 10-10, the motion to amend fails. Yeah, but Horrigan voted no. Okay, all right, so now we're back to the main bill. So now we're back to the main bill, HB 283, as introduced. So is there a motion on that?
I move on to pass on the original bill as introduced.
Is there a second?
OTP.
the motion is OTP, Representative, I'm sorry, moved to Representative
Me,
Horrigan
Horrigan.
moved. All right, withdraw. So there's been a motion made by Representative Horrigan, to OTP House Bill 283 in its original version. Is there a second to that motion? Seeing no second, the motion, I'm sorry, Representative Devine, you second? All right, so the motion has been made and seconded to adopt House Bill 283 as originally presented to us. Does anyone wish to speak to the motion? Representative Horrigan?
I just think the original bill was simpler and more workable than the amendment, although I have mixed feelings about how the vote on that one went. But I think what they came in with the first was the right way to address the issue. So that's why I'm trying to bring back the original bill.
Representative Tripp?
I'm going to say the same thing I said before. If the background check came back with something that required further investigation, that would be an additional charge. And right now, the charge is limited to $35. In the other instance, if the application fees can't exceed $250, if this bill sticks around, if this law sticks around for a while, I'm sure inflation will cause the application fees to be in excess of $250.
Anyone else wish to speak on the, yes, Representative Devine?
I just think there's a lot of potential for landlords to really kind of take in a lot, especially with the market the way it's going. Rental property is going to be in demand, and $35 a whack for everybody that's competing for limited property or limited rentals. It just seems like it shouldn't even be there. $35 shouldn't even be there. It shouldn't even be, this is illegal in other states. I don't know why it's still legal here in this state, but for landlords, I just don't think it's the right thing. I think, this at least limits it and gives potential tenants or people who are looking for a rental unit, some basis to not get gouged by fees.
All right. Anyone else have anything they want to say? All right. So the motion on the floor is ought to pass House Bill 283 in its original form. I'd ask the clerk to call the roll.
Vice Chairman Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk Hutab votes no. Rep. Perez.
No.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
No.
Rep. Turer.
No.
Chairman Lynn.
No.
Motion fails 8-12.
12 to 8, OTP fails.
Would a motion to reconsider the vote on the amendment be in order at this time?
As I understand it,
Okay, well,
a motion can be made. But you don't have to be in the majority or the minority. A motion to reconsider can be made.
so I'd like to reconsider the vote on the amendment, which I believe was 0422H.
Is there a second?
I'll second it out of courtesy, but I have a question. So are we just voting if it's okay to reconsider right now? Or are we actually reconsidering?
We're voting as,
You have to take a second vote on the amendment.
right, it's a voting as to whether or not we should reconsider. And then if we vote that we should, then we will vote on what the reconsideration will be.
I'll second as a courtesy to my colleague.
All right.
Thank you.
So motion to reconsider it has been made and seconded. I think since we've had roll call votes on everything else, we should have a roll call vote on this. Before we do that, however, does anybody have anything else that they wish to say on the motion to reconsider? Seeing none, I would ask the clerk to, sorry. Yes, Representative Manos.
I'm confused about where we are procedurally, but I would like to see us, we did have some bipartisan discussion about this bill in terms of drafting an amendment, the amendment that failed. So I would like to see us retain this to see if we could continue to work toward a bipartisan solution to it.
Well, okay, so, but let me just, I mean, we have a motion that's been made and seconded to reconsider. Representative Horrigan, would you be willing to withdraw your motion just for the moment so we can have a discussion, a discussion along the lines of what Representative Manos said? I would certainly allow you to make the motion again. Pardon?
Tell us why they retained is preferable. It's like,
Sure, yeah, why don't you, Representative Manos, why do you think that's?
Thank you, Mr. Chair. We did have some bipartisan discussion among colleagues on the amendment that failed, and I'm hopeful that if we retain this, that we can continue to have discussions that would enable us to further amend the bill so that it would be acceptable to the majority of the committee, and that would be my goal.
So, so in light of that, Representative Horrigan, do you want to amend your motion, or do you still want to go with the motion to reconsider?
well, I think I'll go with the motion to reconsider and then we'll.
All right. So I think that motion has that motion been seconded? Yeah. It has been. You seconded, I'm sorry. All right. So, anybody want to just further discuss Representative Horrigan's motion to reconsider the vote on the amendment? Seeing none, I would ask the clerk to call the roll.
Vice Chairman Wallace.
No.
Rep. Alexander.
Yes.
Rep. Andrews.
No.
Rep. Testerman. Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk Kutab votes yes. Rep. Perez.
No.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
No.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
Motion passes 12-8.
All right. So now we are back to the question of voting on the amendment.
So I'm doing this in the hopes of being able to vote for the amendment because the original bill was rejected by a majority of the committee, whereas this one has a better chance of the oath getting to the floor. And that was, so. That's big.
So
Both of them are a
so
great
there's a
improvement
motion to, there's a motion now to vote on the amendment that had failed before. Is that motion seconded?
Yes.
All right, so Representative Smith seconds that motion. All right, anyone want to have further discussion on the motion? All right. This is on the amendment. So, all right, so we're ready for the question. Then I'll ask the clerk to call the roll on the amendment 422H of whether we should adopt the amendment.
Vice Chairman Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk Kutab votes no. Rep. Perez.
No.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
No.
Motion fails 10 to 10.
Mr. Chair,
Yes.
I move that we retain House Bill 283. I think that there's an attempt to work with this, at least as far as the amendment goes. The underlying bill I can't support and would not want to work with that as a template. But at least the amendment is someplace where we found some common ground. But I do see where it could be problematic. There's a problem that does appear to need to be solved, and that is the excuse me, the collection of fees by landlords when there appears to be no attempt to lease out a unit. And then there are these holding fees that we heard about that could run into the thousands, or somewhere around $1,000 or more. And these fees are not refunded. It's all big questions that are left unanswered. And so because there is something that there appears to be something bubbling out there, an attempt is being made to address that, this just may not be the right way. So what if we retain it and see if we can't address that? And if we fail, well, so be it. I won't lose any sleep.
All right. So is there, so are you making a motion to retain?
I did.
Okay. And is there a second?
I second it.
Representative Manos, seconds. Any further, discussion on the, yes, Representative Alexander.
Thank you, Mr. Chair. I think this is another assault on free markets and landlords, and I don't even think a retain would get me to a yes, but I'm seeing where the votes are going, so thank you.
All right. Anyone else wish to comment? I have to say, I'm with Representative Alexander. I think that this is not a good idea, but that's just
I
my
think
view.
you're putting landlords in a position that they're going to just raise their credit limits and do things that they wouldn't normally do, so that they have a choice of who they're renting to. They're going to end up having to change things for different people, and it's just putting them in a very, very bad position.
You know, can I raise just a procedural issue here? We're back to the amendments. So we're back to 283 as it is, to retain. Yeah, okay, so, yeah, that's the issue. So do we want, is anyone else, there's been a motion made?
Mr. Chair,
Yes,
I would just like to make some comments,
certainly.
if you will. Thank you, Mr. Chair. You know, I'm not comfortable with the way this bill is going and our response to the bill. There's been a lot of speculations about what landlords will do, what they won't do. We talk about inflation. I've never seen inflation raise an application fee. That would be granular. I mean, if the inflation goes up like 8%, you're going to increase your application fee 8%. I don't think landlords have time for that. So I feel like we need some expert advice here and not speculation, because I think we're getting into the dunders or something, and we're not making sense. You know, we're not basing things on science or experience or anything else like that. Thank you.
So, yes, Representative Tur.
Yeah, the idea of retaining seems appropriate to me, given that, you know, two of the members that sort of are not supporting the amendment are named on the amendment, and it feels as though they want to, making the motion, see a way forward or a possible way forward with this bill. In response to the question of landlords not being able to rent to who they want to, I just don't see that in this bill. It almost simplifies their world because they essentially will choose the person they want, and then that's who they will collect the application fee from once the decision's in place. So it feels like it solves the problem of rampant productive application fees that cost people a lot of money, while also sort of streamlining the whole process for the landlords as well, in my opinion. So for both of those reasons, I like the idea.
All right. So. All right. All right. So anyone else wish to be heard on the motion to retain? All right. So the question before the committee then is motion to retain House Bill 283, and I'd ask the clerk to call the roll, please.
Vice Chairman Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
Yes.
Clerk Kutab votes no. Rep. Perez.
No.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
No.
Motion passes 11-9.
All right. So 11-9, retain. All right. All right. Wait. Yeah. Yes. All right. Thank you all for your indulgence on this. That we had a good discussion. All right. Moving on to House Bill 401 relative to evictions based on the owner's intent to renovate. The chair recognizes Representative Perez for a motion.
Thank you, Chair. I would like to move that this Bill 401 be ITL'd.
All right, is there a second? Seconded by Representative Wallace. Representative Perez, would you like to speak to your motion?
Yes, there's several things that concern me. I don't have a problem with the fact that if I want to renovate my unit, that I have to give my tenant 60 days notice. I don't have a problem with the fact that I would have to let them know what the repairs we're going to do. I do have a problem that I probably will not be able to give them a time frame, because who knows when you can get someone. What I have a most problem with is if I'm renovating, this limits my ability to renovate, to take something off the market, or to perhaps stop renting it out, or to sell. It establishes discretionary stay of up to 6 months. It says that it can't be returned to the retail market within 12 months. If it does, then there's liability involved with it. I just think it just limits, again, the ability of the landlord, the owner of the property, to do what they feel is right or need to do for their own property.
All right. Anyone else wish to be heard on House Bill 401? All right. So the question before us is on the motion of inexpedient to legislate on House Bill 401, and I would ask the clerk to call the roll, please.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman. Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Kutab votes yes. Rep. Perez.
Yes.
Rep. Smith. Rep. Horrigan.
No.
Rep. DiLorenzo.
No.
Rep. Eaton.
No.
Rep. Page.
No.
Rep. Macbeth.
No.
Rep. Devine.
No.
Rep. Lanza.
No.
Rep. Manos.
No.
Rep. Turer.
No.
Chairman Lynn,
Yes.
motion fails 10 to 10.
Is there another motion? Si-
Is it
No.
the ITL that just lost? So
Just
then
the,
ought to pass as an alternative? So-
Well, is there, I mean, I guess you don't have to make a motion of ought to pass. It would go to the floor with no with no recommendation, whether we whether there's a motion ought to pass or not.
But it wouldn't have a report.
But it wouldn't have a report. That's right.
No, excuse me.
Can it be,
Yes, it would have a report. Somebody could choose to write a report for ought to pass, and somebody could choose to write a report for ITL.
even if there's no motion for ought to pass?
Yes.
Oh,
There will be,
okay.
there would be a report on each, it's all left, but I'm virtually positive that I'm correct. There would be a report on each side.
Oh, okay, all right. That's,
I'm going to make the motion not to pass just so that
I'll
the
second.
votes will be there.
Yeah,
All right.
second.
all right. So motion of ought to pass has been made and seconded. Do either Representative Macbeth or Representative Horgan, do you wish to speak to your motion?
I just think, well, I co-sponsored this bill, so obviously I liked it. I still like it. And it, my opinion probably doesn't go far enough. Like there's not much in the way of guarantees that the renovations will actually be done. But I think if the landlord's concerned about selling the property and then getting hit with somebody getting hit with a $10,000 penalty, well, first of all, you can avoid that by doing your due diligence if you're the buyer, because that's one of the encumbrances on the property you have to ask about. And of course, the prospective seller also has the option of getting I know, well, of course, that's not always easy, but getting the tenants to leave voluntarily. Like certainly probably most tenants would probably move out if you offered them $10,000, for example. But so I think, I know not everybody's totally satisfied with the bill, but I think this is a step forward and we should pass it as is.
All right. Anybody else wish to be heard on the motion of ought to pass? Seeing none, I guess we're ready for the question then. I'd ask the clerk to call the roll on House Bill 401, the motion being ought to pass.
Vice Chairman Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman. Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk Kutab votes no. Rep. Perez.
No.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
No.
Motion fails 10 to 10.
All right, so this, are there any other motions? All right, seeing none, so this will go to the floor without recommendation. Representative Perez, I'll ask you to write the report for ITL, and who will write the report for OTP?
Do you want Cam Kenny?
Yes.
All right.
Wait a minute. I don't think so. He wasn't here to vote. He could speak on the floor,
Okay,
but I don't think he can write the report.
all right, so,
I'll write the report.
all right, Smith.
But we can certainly consult with Cam or anybody else we want, any other experts we want to before writing it. Yeah, thanks.
All right, great, all right. So moving on then to House Bill 469, prohibiting discrimination against tenants holding certain vouchers for purposes of renting dwellings. The chair recognizes Representative Kutab for a motion.
I move ITL.
Is there a second? Seconded by Representative Wallace. Representative Kutab, do you wish to speak to your motion?
I found the testimony from the landlords that they're able to decide to take them or not, and some of them have formulas that they use on a basis because it is a risk to them if they do take the voucher that the tenant can do a midnight move out, and they're not guaranteed those funds if they do that. And so several of the, landlords had mentioned that sometimes they're willing to take that risk for a few of the units, but they don't want it to be for, necessarily all of the units in their home. And it seemed like what the real underlying issue was obviously a housing supply, but also it was mentioned that the person who was receiving the voucher only had 60 days to find a property after sometimes waiting for 10 years. It seems like the real problem is that they should have a longer period of time to find, and that's, what should perhaps be fixed, and not forcing the landlords to take something or not, because it does put a lot of regulations onto them, and not all of them perhaps want to do that. It should be their choice. It's their property.
All right, anyone else wish to be heard on House Bill 469, the motion ITL? Yes, Representative Horgan.
Well, I think, certainly the Section 8 program, there's the supply of vouchers is vastly insufficient. And certainly the way the market is in this particular market, in this region, that waiting period is kind of not very useful. Although on the other hand, there are some landlords who specialize in federally subsidized housing, some of which are even for-profit companies. So that is a market that some entities actually do serve and prefer to serve. And the tenants have, you have a third party in the contract, which complicates things, and it's a third party, the federal government, which is the same size as the landlord, or actually probably in most cases bigger. Well, the federal government is backing up a housing authority, so it is does become a more even, the power structure is more evenly structured. But the things that the housing authority are demanding of the tenants and of the landlords, I actually read all the regulations. I mean, it is a pretty good sleep aid if you suffer from insomnia, if you're losing sleep over anything that happened here today. But it's there's nothing in there that I think is terribly unreasonable. Those are like rights and responsibilities that should be taken for granted in any landlord-tenant relationship. And the only real difference here is that you have an entity actually making sure that the parties live up to the agreement, and otherwise it's kind of like the Wild West, as we've heard. And also, I think in the future we may be moving to more subsidized housing, because like even with the rents as high as they are, the vacancy rate non-existent, there's still not much. I mean, there's some new rental property being built, but not enough. And at least to believe the advocates for the private landlords are just barely, hanging on. Like if you have inflation or the boiler going out or whatever, then it's a disaster. They don't seem to have. They seem to feel they have no margin for error. So we may have to go to more subsidized housing in the future anyway. So I think this is a Section 8 is a good program. It probably needs to be tweaked. Certainly needs to be expanded. But I think. I don't think landlords should be allowed to discriminate against the people who are holding the vouchers. And of course, especially a lot of them, they're likely to be from a local socioeconomic class. They may be different from the other renters in other ways, visible or invisible, but they have the same rights as everyone else. So you shouldn't be discriminating them just on that basis. So I recommend voting no on the ITL, and then voting yes on the subsequent ought to pass. So,
All right.
Thanks.
Thank you, Representative Horgan. Representative Macbeth.
Thank you. I think I have the right bill. I think this bill, it didn't require landlords to do anything except not say no, that they wouldn't accept them. So you can't like what you don't see. And I just, I thought it was a good requirement just to allow anybody to apply. It's a free market. So instead of saying no, certain people can't apply, this would allow free market. Everybody gets to apply. No commitment on the landlord, no requirement that they grant a certain amount or anything, just that it's a free market and everybody gets to submit their application. So, thank you.
Yes, Representative Greason.
Thank you, Mr. Chair. Something that I've not heard yet brought up that came to mind is that insurance companies will often look at how many Section 8 tenants you have and that can play a role on your insurability or your premiums, and may or may not. I don't know what those are, but we would end up having to go into insurance laws and make sure there are no conflicts in there. If anything would have to be modified over in that section. So that just opens up a huge can of worms that if this bill were to pass. So I would have to oppose it just based on its current reading, just based on this becomes problematic.
All right, Representative Alexander.
Thank you, Mr. Chair. This is a bill that would penalize landlords if they refuse to rent, not refuse to take an application, but refuse to make a rental to a person holding a Section 8 voucher. Section 8 vouchers require that a landlord follows over 70 pages of regulations, and my friend Representative Horrigan said he falls asleep at those regulations. I mean, I couldn't imagine having to read all those pages and follow all those extra regulations. And so this is a rental refusal. This is just an assault on landlords. They have a right to allow anybody to rent to anybody, and this bill is just another regulation we don't need.
Representative Smith.
Thank you. I'm not 100% sure that Representative Alexander was completely accurate in what landlords can and can't do. But my question really is for Representative Greason. This is a whole new area for me. I wonder if you could give me the documentation or the citations that indicate that Title 8 tenants cost more in terms of insurance. I would have thought it would go the other way since there's a guarantee that the rent's going to be paid, which is better than not having that guarantee. So I need your advice, Representative Greason.
My advice is read the laws. I said I don't know what the impact would be. They may go up, they may not go up. I'm saying I don't know, but it opens up the question about insurance, insurability. I don't know if it will or not.
I see. Okay, I misunderstood you. I thought what you were saying is that yes, it would increase the rates, and thank you for that clarification. I really appreciate it.
All right.
If I just.
Oh, yes, Representative
Mr. Chair,
DiLorenzo, please.
You know, I've been a landlord. I was a landlord for 35 years. My companies that I worked for, we took Section 8 vouchers. I was heavily involved in the financing of our properties, the operations, the accounting, audits by the government, private audits, and I have never, ever, ever heard that insurance rates tend to increase when landlords accept vouchers, Section 8 vouchers, or any other kind of subsidy. So that's just not true. Thank you.
Anybody else have anything to say on House Bill 469? The motion before us is inexpedient to legislate. Seeing none, I'd ask the clerk to call the roll.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman. Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Utab, yes. Rep. Perez.
Yes.
Rep. Smith.
No.
Rep. Horrigan.
No.
Rep. DiLorenzo.
No.
Rep. Eaton.
No.
Rep. Page.
No.
Rep. Macbeth.
No.
Rep. Devine.
No.
Rep. Lanza.
No.
Rep. Manos.
No.
Rep. Turer.
No.
Chairman Lynn.
Yes.
Motion fails 10 to 10.
Is there another motion?
No,
Representative
no,
Horrigan?
no one else. I'll bring forward an OTP.
All right, is there a second? Second by Representative Macbeth. Anybody wish to be heard further on this motion? Seeing none, I think we're ready to call the roll on the motion now is ought to pass on House Bill 469. Ask the clerk to call the roll.
Vice Chairman Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
No.
Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk Utab votes no. Rep. Perez.
No.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
No.
Motion fails 10 to 10.
Mr. Chair, I'm getting bored.
All right. Um, so, Representative Kutab, I'd ask you to write the report in favor of ITL, and who will write the report in favor of OTP?
Well, I made the motion, so I guess I'll do it probably in,
All right, all right.
probably in close consultation with my other two committee members
Or-
from
And
Stratford
Representative
10.
Oregon, the report of ought to pass.
Thank you. Could you make sure, Tim, that I get that report as soon as possible?
Yes, please.
All right. So next, we will turn to House Bill 567 relative to notice of rent increases in certain residential rental property, and I recognize Representative Kutab for a motion.
I move ITL.
Is there a second? Seconded by Representative Wallace. Representative Kutab, would you like to speak to your motion? And take your time. No, you've got a million pieces of paper in front of you. Take your time. Take your time.
I believe that this is just putting unnecessary controls onto the free market. I think that 6 months is an excessively long amount of time. It's very difficult to plan what's going to happen 6 months out. I think we all recently had our electric rates go up as well as our, home heating rates. And that was something that couldn't necessarily be predicted 6 months in advance. And so I think it's putting kind of an unnecessary burden on landlords to predict what something may or may not be going up. So I think we have a big housing shortage, and trying to further restrict the market is going to have a detrimental effect on it.
Anyone, other people wish to be heard on House Bill 567? All right, are you ready for the question? All right, then the motion before us is inexpedient to legislate on House Bill 567, and I would ask the clerk please to call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
There you go.
He left the room.
Oh. Okay.
okay.
Well,
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab votes yes. Rep. Perez,
Yes.
Rep. Smith,
No.
Rep. Horrigan,
No,
Rep. DiLorenzo,
No.
Rep. Eaton, Rep. Page,
No.
Rep. Macbeth,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Chairman Lynn.
yes.
Motion fails 9 to 10.
Okay, so.
Zoe.
You were. Yeah,
Zoe?
so,
That we have.
so the ITL 10 to 9. The,
9 to 10.
I'm sorry, 9 to 10. ITL fails. Is there another motion?
Representative Manos?
Yes.
Thank you, Mr. Chair. I have an amendment that I have circulated to the bill, and I would like to propose the amendment. I think,
So you're moving OTPA.
yes,
CTA, yeah.
thank you,
Let me get the, hang on one second. Do we, I think we have that, right? Hang on one second.
yes.
Five,
Is there a second?
oh, yeah, I'm sorry. Is there a second on the motion?
Page seconds.
567, hang on.
Sorry, could you tell me the amendment number one more time, please?
Yes,
429.
0230429H.
And so the motion, the amendment, motion to amend has been made and seconded. Representative Manos, would you like to speak to your motion, please?
I would, Mr. Chair, thank you. The amendment that I have proposed addresses some of the points that Representative Kotab made. It would restrict to 60 days the notice of rent increase rather than the proposed 6 months. It also eliminates paragraph Roman numeral 3, which would have given tenants the right to terminate their existing lease with 10 days notice. And so I think the amendment is addresses the concerns that have been noted about this bill.
All right, anyone else wish to speak with regard to this? I'm sorry, Representative Tur, did you?
Yeah, just I think the removal, particularly of Section 3, to me really strengthens the bill by removing what I think would not have even been a probably ultimately legal requirement to terminate a lease just based on a notice that in some future time the rent after the lease would be increased. So I'm hoping we'll have a chance to talk about the bill as amended.
All right. Anyone else wish to speak? So I guess I would just say, I repeat what I said before. The more of these kind of restrictions you place on landlords, the more you make housing unavailable, at least to some extent, or the rent goes up. So I don't think that I will not be supporting the amendment. All right, anyone else wish to speak? Yes, Representative Perez.
What if I pay the utilities on this apartment? I pay the electric and I pay the heating utilities. My electric and heating has gone up far more than 15%. And I think, and on top of that, my assessment on my house has gone up and my taxes have gone up more than 15%. We need to take that in consideration when we're setting a cap on landlords.
All right. All right. Anyone else wish to speak?
Can we just?
Yeah.
Oh, I'm sorry.
Yes, Representative Tur.
No, I was just saying I don't see that this sets a cap per se. It just sets a notification requirement. If I'm reading it right.
All right. Anyone else wish to speak? All right. So I'm sorry, Representative Stapleton.
Thank you, Mr. Chair. I think the 6 months written notice of intended rent increase is so egregious that the amendment removes that, and I think that's a good thing. I'd kind of be inclined to accept the amendment if maybe I didn't even accept the bill.
Can I ask a question? I just want to make sure I'm understanding. So I see that the amendment is replacing section 1, which if my memory serves me correct, was relative to the notice, but there was another section relative to the tenant and giving notice to vacate. Is that correct?
You know what, when it says section 1, it really means this. So that's all the way down to that's everything except the effective date, right? Is that correct, Representative Manos?
I believe so.
See what I mean? In other words, so it says, amend RSA as inserted by section 1 of the bill by replacing it with the following. So as I understand your amendment, it replaces all of section 1 of the bill, which really is everything except the effective, down to the effective date. Okay, so it does replace this part too. It replaces Roman numeral 1, Roman numeral 2, and Roman numeral 3.
So it's no longer saying that the tenant can terminate the lease with 10 days notice anymore. It's just saying you have to give a notice, but there's no more they can leave in 10 days.
Correct.
Okay.
Anyone else wish to be heard on this? All right, seeing no one. So the question before us then is on Representative Manos's amendment 2023429H. And I guess we'll have a roll call vote on the amendment.
Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman,
No.
Rep. Stapleton,
Yes.
Rep. Tripp,
No.
Rep. Greason,
No.
Clerk Kutab votes no. Rep. Perez,
No.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn,
No.
motion passes 11 to 9.
11 to 9. All right. All right, so now we are on to the main bill as amended. So it's 567 OTPA as amended by Representative Manos's amendment. Does anybody wish to speak further on that bill? Seeing none, are we ready for the question? All right, so then the motion before us is OTPA on the bill as amended, and I would ask the clerk to please call the roll.
Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman,
No.
Rep. Stapleton,
No.
Rep. Tripp,
No.
Rep. Greason,
No.
Clerk Kutab votes no. Rep. Perez,
No.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn,
No.
motion fails 10 to 10.
All right, so, yes, I guess, it'll go to the floor, without recommendation. And so, Representative Kutab, would you write the report in favor of ITL, and who will write the report in favor of, OTPA?
I believe the motion on the floor is going to be, it's OTPA, but the first motion is OTP, right? So the amendment
Right.
would have to be approved again on the floor. Am I?
Right,
Is that
that's right.
right?
It would have to be
Okay,
approved.
just
that's-
making
yes,
sure.
Yeah,
Thank
yeah,
you.
you know, you're right, you're right. All right. TL and Manos is gonna write the report. The OTPA.
Hesitate to ask us, do we have to have a vote on the ITL, or can we just go ahead and?
No, we
Yeah, we're
we
good.
voted on the ITL and
Yeah,
it failed.
Yeah.
It failed, yeah, so, but,
Put 235 on a consent calendar.
What's
No
it?
recommendation, and there'll be somebody for it, for OTPA, and someone ITL.
right. Oh, yeah, you know what, yeah, that's, no, exactly. So let me just ask, I'm sorry to do this, but Representative Wallace brings up a very valid point. On HB 235, which that's on the committee now to study expansion of landlord tenant mediation. Is there any reason that can't go on the consent calendar? Anybody object to that being on the consent calendar?
That was 18 to 1.
Yeah, 18 to 1, ought to pass.
No, I
Cons-
think
I think
I
you
asked it to go on.
Okay,
already
yeah,
marked it
all
down.
right, so it's on
Okay.
consent,
No,
okay,
I should-
it is on consent, all right, all right. So hang on one second. Let
Can
me
we
go-
pause for 1 second?
Yes, of course.
Something that she needs to know for the calendar.
Of course, absolutely.
It's regarding the amendment number
It's getting hot.
for, HB 162. What is the correct amendment number on there? She has,
162, wait a minute, hang on. let me
she has
find it.
175 and 116, she wants to verify.
162, wait one second, let me find it. Oops, 162. No, 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 no. Let me see, the 162, the proper amendment that is 116H on 162. 116H. Yeah, all right. So, now we are up to, House Bill 641, and, hang on one second. So this is the proposal. Yeah, we're gonna retain it. All right. So, and,
Yeah, that was Joe and Kate.
okay, so Joe, yeah, all right, so, all right. So, on House Bill, 641, I'd recognize Representative Alexander for a motion.
Thank you, Mr. Chair. I move to retain HB 641.
Is there a second?
I second.
All right, Representative Alexander, would you like to speak to your motion?
Yes, Mr. Chair, I'm actually a real glutton for punishment, and I like to spend the summer months in this committee room with a small subcommittee working on this bill. It's clear that there's some work we can do. I think DHHS came in and gave us very important information regarding the clearance reports, regarding the lead inspectors, how they're paid, how long it takes the clearance report, how long they have to turn it over. DHHS indicated there's some wiggle room there, such as moving the required date from 14 days to 30 days. And then on top of that, I have an amendment floating around that I think is a good amendment, but there's still like a lot of stuff up in the air regarding this bill. And I think that maybe, unlike other bills we've had today, this committee could actually sit down and come up with something. And if we can't, we can't. I get it. But I'd kind of like to learn more about how lead inspectors are paid. So I hope the committee will vote with me on this. Thanks.
Representative Kutab.
I second a lot of what Rep. Alexander just said, and I just wanted to also mention that HHS had made comment that they were willing to get together with the lead inspectors as well and try and, perhaps find a compromise for a solution on the rules so that it wouldn't necessarily have to take legislation. And so I think it's worth retaining it and seeing if they're able to come to a compromise. And if they're not, then perhaps we go the legislative route. So.
Anyone else have any? Yes, Representative Alexander.
Yeah, just to add to that, I think it's important that we encourage that behavior and then hold on to this bill just to make sure that that conversation is happening, because I think this is a real opportunity for it to be solved in the regulatory, the bureaucracy, but I like, the general card to have a play that if we can. So I'd like to be maybe even a mediator in the process. Thanks.
All right. Anyone else wish to be heard on this? Representative Manos.
I'd appreciate just being reminded, I'm not remembering the testimony of lead paint inspectors who hadn't been paid and that this was problematic. So if other members would remind me of that testimony, I would appreciate it.
Well, I will respond with my recollection of what I heard. Other people may have a different view. And I want to emphasize here, I am going to vote to retain with, for the reasons that Representative Alexander and Representative Kutab have stated. But I have to say that the testimony that I heard suggested to me that there is one inspector who was having trouble getting paid and could have demanded, as apparently other lead inspectors do, could have demanded a deposit up front. And would have, and so I hope we will be able to come to some resolution that will, make things better in terms of the relationship between lead inspectors and the Department of Health and Human Services. I can't help having the taste in my mouth that this proposal is designed to sort of put the legislature in the business of helping a creditor who could easily have helped herself by simply getting a deposit up front. And I'm not sure we ought to be doing that. But nonetheless, maybe there are other things, that as Representative Alexander and Kutab point out, maybe there are other things that we can, are worth doing. And I'm perfectly fine with retaining the bill. But I guess I would say that it will take a lot to convince me in the fall that we ought to be in the business of legislating to sort of help a business person collect on a debt that they could easily have protected themselves and collected on their own. That's my view. Other people may have a different view. Yes, Representative Stapleton.
Yeah, I share that particular aspect of the view that the legislature shouldn't be in the position of mandating something that could otherwise be handled properly with other remedy. The deposit, for instance, is there any prohibition against deposits or retainers for these things? I mean, how much are these fees for lead inspection? Do they run a gambit of so many dollars to hundreds, or where are we at with that?
My understanding is they can be quite expensive, but I believe, as we heard at some point, that apparently there are other inspectors who do get security deposits, up front of some percentage or maybe all of the. So anyway, yes, Representative Horrigan.
I was when my mother sold the house she shares with her father, we had to go through a lead inspection process for that sale, and as far as I know, we paid the fee without any drama. But like in that case, and that's probably the case in all cases, it was in both parties' interest to get that issue resolved as soon as possible. The family who bought the house wanted to move in as soon as possible, and my mother, of course, wanted to sell it and collect the money as soon as possible. So I'm not sure why this is happening, except occasionally if you just get an irresponsible seller or buyer involved. So.
Yeah, so I guess I want to say though, I do have the frustration that I just pointed out, but I do think that Representatives Alexander and Kutab have a really valid point, that it appears that there are some issues at the Department of Health and Human Services that maybe could be sort of addressed better, and so retaining it, I think, probably does make some sense. If it turns out in the fall that nothing has changed, then I know what my vote will be, but maybe we will get some additional information.
And thank you, Mr. Chair. I had a private conversation with members in this room from DHHS, and they're comfortable with retaining as well in order to have a conversation, and maybe we can facilitate the conversation between the two, or
Sure,
work on it. So.
Sure.
Can I ask one quick clarifying?
Of course, yes, Representative Turer.
A lot of the conversation when the bill was heard revolved around an amendment that was offered by Representative Kelly, Hillsborough 32. So I don't know, is that incorporated into what you were thinking?
Yeah, I planned on, actually, I have an amendment I circulated earlier that I think would completely replace Representative Kelly's bill, but add some things to it. So I mean, the bill is introduced is a mess, in my opinion, but I think that the amendments kind of get us closer where we need to be. So I'm not introducing the amendment because I want to look at that in the retention process.
Okay. Yeah, I agree with the statements that it probably could be avoided altogether, and it's fairly narrow, but in the name of giving you something to do over the summer, sure.
we don't want you to be bored, Representative Alexander. All right. So the motion before us is to retain. It's been moved and seconded. Is there any further discussion on the motion? Seeing none, I would ask the clerk to please call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
No.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Eaton,
Yes.
Rep. Page, Rep. Macbeth,
Yes.
Rep. Devine,
No.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes, with a sigh.
Motion passes 18-2.
Mr. Chair, I invite anybody that voted yes to sit with me on a subcommittee. I'm sure I'll be in charge of this summer, so please feel free to reach out.
And Mr. Chair, does this mean that Representatives Stapleton and Devine don't have to sit on that committee?
That's right, yes. All right, moving on to, House Bill, 362, relating to, the procedures before the Human Rights, Commission. Yeah.
Motion to retain?
All right. Is there a second to that? Representative Stapleton seconds. Representative Smith, would you like to speak to the motion?
No, but I will. Your mic's off.
Oh, your mic's off, Representative Smith. Thank you.
Thank you. I don't imagine anyone really wants to hear me anymore. I'm moving to retain this bill. The situation at the Human Rights Commission is very complicated. The bill that we have before us had come from the Senate last term. We worked a lot on the issues over the summer. We came up with a bill to address one very small problem, and it's only a small problem when there are many other problems. Since the term began, the Joint Legislative Committee on Performance Audits has met and decided to do a thorough performance audit of the commission. That request was sent to the Fiscal Committee, which agreed. That causes me to suggest that we would be more responsible by voting to retain this bill now, letting the LBA Audit Division do their magic, and also giving many concerned individuals and institutions outside of the legislature time to talk with us about ways that we might really improve what is happening at the commission. And therefore, I would urge the committee to support the retention motion.
Anyone else wish to be heard? I guess I am going to vote for the retention motion. I join much of what Representative Smith has said. I think it will be helpful to hear what the audit has to say. I'm not sure. I don't know whether we'll have that by the time we have to make some decision, but hopefully we will. And the other thing I guess I would say on this is, it really does seem like there are a lot of issues with respect to the Human Rights Commission, and the proposed bill really doesn't address any of those things. It does, in one sense, it does solve a problem that the people who testified in favor of it raised, which is it unfair to allow a respondent to remove a case after a finding of probable cause is made, particularly when it often takes years for that finding of probable cause to have been arrived at, which it's hard to understand how that happens, but it does. But that doesn't really deal with the whole issue of why does it take so long. I personally happen to think that that although that might make it fairer to claimants to remove, as the bill proposes to do, the respondent's right to make any to remove is not fair to respondents. And so I had proposed an amendment that would have allowed respondents to make motions to remove, but it would have to do it very quickly after the 180-day period expired. That seemed to me to be a little fairer to both sides, correct the problem that the plaintiffs were complaining about, but make it fairer to the respondents. But I have to acknowledge that maybe that's not the best way either. Maybe there are better ways to do this that would be fair, that would be even more fair to both sides. And I think for all those reasons, I think that what Representative Smith proposes makes a lot of sense, and so I plan to vote to retain. Yes, Representative Tripp.
Thank you, Chair. I'm new to this committee, but it piques my interest that we are retaining so many bills. Is this something that's common practice in judiciary?
The answer to that is no. I think there are a number of reasons why we are retaining so many bills this time. And to tell you the truth, I believe one of the reasons it has to do with the physical plant. The fact that we now have half as many committee rooms as we've had in the past means that we have to share committee rooms with people, and therefore we do not have the opportunity to have work sessions the way for all the previous years that I've been in the legislature. We were able to take bills and spend time in work sessions to try to solve the problems. And so that is one reason. Another reason is the very practical reason, Representative Tripp, that when the voters of New Hampshire sent us to this particular legislature, they either made the wise or the unwise decision of having us, and I'm not ready to vote on that one yet, to have a very close number of Democrats and Republicans. As you can see on many of the bills, we have not taken partisan votes. On many of the bills, we've agreed either ITL or OTP. The few bills where, and it's the minority of the bills we've had, where we haven't been able to reach agreement, we could go to the floor with no recommendation, but it seems somehow more responsible to keep the bill here until we can see if maybe we can come up with an agreement. So the reasons both of physical plant and of party distribution, I think, means that in this committee and in many others, we're going to see more retained bills this year than usual.
Well, all I have to say is you had me at the physical plant thing. If we're not able to hold workshops, then obviously that we have to have some means of continuing to work on a bill. So retaining is the alternative. Thank you.
Any other comments on the motion to retain on House Bill 362? So are we ready for a vote? Right, I would ask the clerk to please call the roll.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Hutab votes yes. Rep. Perez. Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
Unanimously 20-0.
No, it
No,
doesn't have
no,
to
it
go.
doesn't have to go. It's a, right.
I know, I'm so
All right.
tired.
All right. So the next, with regard to House Bill 533, I'm going to defer having any vote on that now, and suggest that we have a work session. There are there are some, I guess what I would say is this, and I'm reflecting my own sort of view on this bill. Other people may have different views, but one of the things that concerned me about the bill was that it proposed to give the Department of Education the authority to, and prosecution is probably the wrong word, but to bring claims before another agency, the Human Rights Commission, on its own. The Department of Education could do that on its own. And apparently, although I'm not sure the bill necessarily had to be read this way, but apparently all the people who were testifying were reading it this way, that the Department of Education could bring such a claim before the Human Rights Commission, whether or not the alleged victim agreed that this could happen. That kind of concerned me because, as I understand it, it would be the only state agency other than the Department of Justice that would have that power. I'm not quite sure I understand why that would make sense to give one particular agency that power, particularly when, I went and literally read the statute yesterday, 354A specifically gives the Department of Justice the authority to do that, whether or not there is a complainant that agrees. So the Department of Justice can do that on its own. And that, I'm not sure why that's not sufficient. Apparently, as I understand it, there's at least been a suggestion that the Department of Justice either doesn't think it has the authority to do that or is reluctant to do that for some reason. I don't know, but the Department of Education has asked for some time to try to work something out with the Department of Justice, and maybe other people who have an interest, and to come back to us with some, with hopefully a proposed agreement on how they might be able to deal with this, which, that, if there's a possibility of coming up with something that everybody is kind of on board with, I don't see any reason not to do that. This is not an early bill. So that's why I am in favor of giving them a little more time to do that, and we'll see what happens.
Mr. Chair, I think that's a decision that you have the power to make, and so there's no need to discuss it. You have the power to decide when we will accept on bills. So we can just move on to the next
All
one.
right, great. All right. House Bill 543 relative to discrimination against veterans and price discrimination among other protected classes. The chair recognizes Representative Testerman for a motion.
I make a motion that we ITL this bill.
Is there a second?
I'll second that, Mr. Chair.
Seconded by Representative Greason. Representative Testerman, do you wish to speak to your motion?
Just very shortly. These kind of bills, and I'm a 20-plus year veteran, I just find a lot of these things obnoxious and a lot of other things. I don't believe that, we are being mistreated as veterans. I find, being put into a list of people who do think they're being mistreated about something is really offensive to me. So I think this needs to be ITL'd.
Anyone else wish to speak to? Yes, Representative Kuta.
I just wanted to say that I noticed in the top section, it was saying that it kind of protected discounts and stuff, but then in the bottom section, it actually was saying that they couldn't offer discounts, which was really conflicting and also concerning, because I know a lot of places do tend to offer veterans discounts, and we also didn't have any veterans that were coming out and saying that they had ever been discriminated against, that it was a problem. There was nothing. I just checked to see if anything had been submitted online, and there wasn't anything online either. So in the absence of any examples of it happening and the potential to do more harm than good with the fact that it may be taking away discounts that veterans are currently having, I agree with ITLing the bill.
All right. Anyone else have anything they want to say on HB 543? Yes, Representative Stapleton.
I'm also a veteran, and I think this bill is a solution looking for a problem. And I would oppose the I'd be with the ITL.
All right. Anybody else have anything they wish to say on this bill? All right, are we ready for a vote on HB 543? The motion before us is ITL, and I would ask the clerk to call the roll.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Kutab, yes. Rep. Perez,
Yes,
Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
we agreed.
Rep. Eaton,
Yes.
Rep. Page,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes unanimously 20-0.
Yes, absolutely. I agree. And Representative Testerman, could I ask you to write the report?
Yeah.
Thank you. Thank you. All right, next, we'll turn to HB 647 relative to causes of action for individual rights, and the chair recognizes Representative Alexander for a motion.
Thank you, Mr. Chair. I move HB 647 and expedient to legislate.
Is there a second? Seconded by Representative Wallace. Representative Alexander, do you wish to speak to your motion?
Yeah, I do. There's a lot of things wrong with this bill. I made a little list. Number one, there's no standard. The one standard we have in here is on page 2, line 23 through 30. It's a use of force standard. And when asking some of the witnesses, I think maybe the committee remembers when I asked about if a Department of Transportation employee paints a line incorrectly, will the court use the use of force standard to prosecute them under the qualified immunity if this bill passes? Number two, there's already an avenue for an individual to sue a government entity if they can prove through just cause that the government entity acted in a wanton or reckless way. A great example, Representative Lynn can probably describe it a little better, but in Manchester, there was a case with police officers acting in a wanton and reckless way, and that is currently in the court system. Number three, this is not just a violation of a constitutional right. This is a violation of any law, any state law, any local law. And actually, the only groups of people that are immune from this bill are the legislature and the judicial branch. So that just goes to show you, if you want to pass this bill, let's just make the legislature involved too, and then we'll all get sued for this stuff. Number four, the argument is there's no individual liability. My problem with this is if there's even just cause that can cause a hearing for an individual police officer, a firefighter, EMT, paramedic, it causes a hearing, and that could be cause for a government entity to suspend an employee without pay. So that lack of pay would be a financial liability under this bill. And number five, there's not even a negligence standard. So you don't even have to prove that the employee acted in a negligent way. You can just say maybe they didn't know, but they still violated the law, so they can sue. So there's a lot of things wrong with this. I could probably go all day, but I hope that the committee agrees with me and votes this down. Thanks.
All right. Other people wish to be heard. Representative Smith?
I think I do want to be heard. Thank you very much. I guess I have a problem. I happen to hold New Hampshire's public employees in the highest regard. I believe that overwhelmingly, despite the fact that we aren't overly generous in salaries, we are pretty generous in terms of some benefits and certainly in terms of retirement. We have terrific public employees. And, but I also believe, and I think it would be hard for anyone to refute this, that there are a few, very few bad apples. And the few bad apples do infect the bushel of all the good in two ways. First, they might put pressure on people to behave inappropriately, but much more importantly, they color how the public views our public officials. They see one problem, one error, and they think, oh, well, that's for public officials. I know that is not true, and you know that is not true. I was not surprised, but I was very, very saddened when I saw agency after agency come in here and say, "Oh no, we can't possibly do this." Well, if the agency, whatever the agency is, used high standards in terms of recruitment, in terms of hiring, in terms of training, all the standards they should, if they provided supervision and accountability, that would go a long way to making sure that there would be no bad apples. If the employer is not willing to provide that kind of leadership, I think that provides a disservice to the public. And that is why I think it makes sense to hold the employer responsible, not the employee. If the employee doesn't follow what's required and the employer is permitting that, then I think the employer should be held accountable. I happen to take very seriously people's civil rights. As Representative Alexander well knows, there is an amendment that I have submitted that changes the language to exclude law and keep only constitutional violations. I think 1983 has been on the books now for what is it? How many years? 150 years. And the recognition of people's civil rights is something that I hold very close to my heart and have spent my whole professional life working to protect people's civil rights. And no one, public official or not, should have the right to believe that they can get a free pass to violate civil rights. The language in this bill, which says very specifically that if a case goes to court, the court cannot use hindsight. They cannot go back. They have to recognize that in many situations, a public employee has to make a very quick decision based on the information that they have available to them. And we might look back in hindsight and say, maybe they could have avoided that. The court can't do that. And if a reasonable person says, yes, under those circumstances, ex-public employee acted the way they did appropriately, that's fine. I'm comfortable with that. But to not recognize our obligation to protect everyone's civil rights, I think also creates an environment in which we're not holding our public employees to the respect that they deserve, the respect that virtually all of them are careful and are responsible and act the way they should. I know that what I've just said is, it's not that it's falling on deaf ears. I think that people on the committee respect each other's disparate views, even though they don't agree. I have no illusion that this is going to pass. But when I see people who, for example, represent municipalities say, no, we don't want the government to be held accountable, I think that's sad. And I think it's a misjudgment of what I would like our public officials to do. In closing, I would just say, and I think I've mentioned this before, in my town of Durham, for example, the police chief insists that there be a psychological test. That is not required, but the police chief believes before he hires, because he is going to be accountable and he wants our police to be accountable, he wants to make sure he hires the best possible people. I have heard it said, well, we're having trouble getting enough people. I understand that. I mean, restaurants are having trouble, factories are having trouble, and yes, public agencies are having trouble. But I do not believe that that means we should say, okay, what the heck, let's just hire somebody who really doesn't meet the standards that we expect our public officials to meet. That is all that this bill does. It recognizes that we value civil rights, that we respect our public employees, that we believe they are behaving the way we would want them to behave, and in the few cases when they don't, they should be held accountable. And it is because of that, Mr. Chair, that I will vote against ITL, and I might be the only one, but I will still vote ITL because the protection of civil rights is central to my beliefs. Thank you.
Anyone else wish to be heard? I'm sorry, yes, Representative Perez.
I agree 100% with you, Representative Smith, but my concern is that in this time, right now, where our police, our fire, our health are being scrutinized beyond anything, and it appears that people are looking at this just for them. I think it's not the time to be doing this, and I maybe there's no good time to do it, but right now there's no way I would ever want to be a police officer and have to make decisions on the spur of a moment with somebody looking over my shoulder and scrutinizing everything that I do. I agree with you. We've just had an incident where I live where I think there's some issues that should be brought forward. I just think that because this appears to be targeted at our police, this is not the time. We need to do everything we can to protect our law enforcement right now. So.
Yes, Representative Manos.
Thank you, Mr. Chair. I live in Stratham. I'm from Stratham, and I met with my town moderator yesterday, and we had a long conversation about it. And we also looped Ms. Burns from the New Hampshire Municipal Association into the conversation. They raised many of the concerns that Representative Alexander expressed. But I also feel strongly that New Hampshire should have a state equivalent of Section 1983. I think it's extremely important that we do that. And so my view would be that we retain this to see whether we can work out over time, over the summer, some of the issues here so that we can see about coming to a compromise that would both be a New Hampshire equivalent of 1983, but be acceptable to the public employee unions and the municipalities, the cities and towns in New Hampshire. And so my thought is that the better course of action for this bill is to retain it for study.
All right. Anyone else wish to be heard on this? Yes, Representative Stapleton.
They use the term qualified immunity, but I'd rather say it's more like a relevant immunity to some degree, because we have avenues in law that take care of those bad apples. And, you know, even in the recent news, we got police officers on trial and going to jail for wanton and reckless actions. We have a good, solid system of jurisprudence and law that takes care of these bad apples. I do agree that the supervision and training has to be improved to locate and remove the bad apples so they don't contaminate the barrel. But I think we're evolving into that as more and more pressure goes on to supervisors. that see they've had people go bad and go to jail for it. I think there's going to be an evolution on this, and for that reason, I don't want to destroy the relative immunity that should be there as a protection on those decisions that are instantaneous and momentary and shouldn't be second guessed.
Anyway, yes, Representative Macbeth.
Thank you. So I certainly respect all the comments of my colleagues. I don't want to be anyone that votes for ITL or against this bill to be painted with a brush that they're not an advocate for civil rights, because I certainly am. And that is something that I take very seriously. I also, there were comments that I didn't hear any municipal or union or any actor say that they didn't want to be trained and properly supervised and that there wasn't going to be accountability for actions. But that's not what this bill does. This bill, any mistake, any small mistake allows a suit to be brought against a town. It can be a voter registrar or a Department of Public Works engineer or anyone. And I think that that's just not where we want to be. That's not talking about bad actors. That's just talking about humans. We hire humans, and humans make mistakes. And so I can't support this bill. I do think that there are issues about qualified immunity that can be addressed, but there are just so many issues here that are really just not appropriately drawn. So thank you.
Yes, Representative Kutab.
I want to echo much of what Representative Macbeth just said, and I also wanted to add to it that I had also heard concerns about town playgrounds. Are we going to need to shut down the playgrounds because it's going to open us up to a huge liability if there's an accident on the playground? Are they going to sue us for it? There was also concerns from my superintendent because there's a big teacher shortage right now, and they're having difficulty with hiring teachers. I do agree that we absolutely need to hold people responsible for their actions, but I don't think that this is the way to do it right now, not in this time.
Anyone else with any comments? Yes, Representative Lanza.
I agree also with Representative Macbeth and also Representative Kutab to say that we need to, as I say, make sure that our police, as well as all our government officials, are, have, let's say, the protection as well. They go out every day and serve, to do a good job out there and take care of and protect as well. And I think what happens is, if we were to pass this, what could happen is they might decide not to ever, there might be police not wanting to come into the police force anymore. And some of the ones that are here might actually choose to leave. Because what would happen would be, it'd be opening up like the chance of what happened is could lose their life savings in regards to just any liability that came upon them. And people work hard, as we all do, to make their savings and to put their money in the bank account. So we need to think about not only, well, so you say anybody, like we said, in whether it be in law enforcement, whether it be municipal employees, as well as government. So I, as well, cannot support this bill. So thank you.
Anyone else with Representative Turer, and then I'll get to you, Representative Smith. Representative Turer.
I know there was an amendment circulating. I don't know whether that is something anyone's spoken to, whether it changes any of this. I must say it the way it's currently written, even though I'd really much like to support this, when I see from the New Hampshire Municipal Association, where it says that the bill eliminates any governmental immunities, requires the government to pay for attorney's fees in circumstances where the government settles or loses in court, and eliminates any collective bargaining protections for employees subject to penalty. Those things I think are troubling. They may sort of speak to what other people have mentioned. I just didn't know whether there was a circulating amendment that might heal any of that.
Representative Smith.
Thank you. As I think you know, Representative Turer, there is an amendment, and the amendment basically removes the the language which talks about law and keeps only the essential language that talks about constitutional violation of civil rights. And I must say, I think we're all tired, and I'm tired, and I don't want to say anything glib, which I sometimes do, but some of this does sound a little to me like Chicken Little, that the sky is falling. There have been lawsuits on playgrounds always. Nothing we can do is going to eliminate irresponsible, irrelevant, frivolous lawsuits being filed. They're filed all the time, and they're thrown out of court because they're frivolous. And nothing we can do can stop those frivolous lawsuits because people have a right to have access to the courts. What this talks about is a violation of civil rights. We're not talking here about whether we're going to complain because the baseball field has turf on it and people want natural grass. That has nothing to do with a violation of civil rights. We are talking only about a violation of civil rights. And if you want your town to hire people who do not want to respect other people's civil rights, that's fine with me. I just hope that my town never chooses to do that. So to say that people aren't going to want to work because they're going to have to honor people's civil rights, I don't find that argument persuadable, and I think I'm probably speaking too strongly, and so I'm now going to stop. Thank you.
Anyone else wish to be heard? So I guess I want to just say a couple of things about this. I appreciate very much Representative Smith's very thoughtful comments. And I also want to address Representative Manos's point about thinking that there should be a sort of a state version of 1983. I think there's a couple of things to bear in mind. First of all, 1983 actions, although they are usually brought in federal court, can be brought in state court. State courts have jurisdiction to hear 1983 actions. More importantly, to the extent this bill, and by the way, I agree with Representative Smith that I think the amendments that she proposes does make the bill better. It doesn't make it, in my view, it doesn't make it appropriate to pass it, but it does make it not quite as bad as it was. I think the important thing to understand for those who say we ought to have a state constitution, a right to bring actions for violation of rights under the state constitution, I really respectfully submit to you that it's not necessary, because the whole reason that 1983 was enacted right after the Civil War was because there, under federal law, there isn't any sort of common law. An assault and battery is not a violation of federal law. A false imprisonment is not a violation of federal law. Any of those kinds of things, and so they needed to have a body if they wanted to enforce the new rights created by the post-Civil War amendments. They needed to create a vehicle by which people could sue for protection of their federal rights. But that's not the case under state law. Almost everything that you might say would be a violation of the state constitution. I'm not saying absolutely everything. I'm sure you could probably come up with some clever thing of what that's not. But almost everything that you could say would be a violation of the state constitution is a violation of the state common law. If the police, use excessive force against someone, that's assault and battery. If the police unlawfully arrest someone, that's false imprisonment. There's a common law tort for that. If they go on your property when they don't have an adequate basis to be there, that's trespass. There's a common law of trespass. So all of those things are already in the law, and there's not any reason to now sort of make a new state constitutional cause of action for those things. And And I guess what I would ask you, you might say, well, what's the problem? If it's already, a common law thing, what's the big deal about making it a constitution? I submit to you respectfully, as much as I love, most lawyers, this is like the Lawyers Full Employment Act, because it will be every issue that was, let's say a common law assault and battery. Well, now we've made it a state constitutional violation, and there will be clever lawyers that will say, Your Honor, those cases dealt with assault and battery. We now have a new constitutional right. You should find that the elements are different or damages are different or whatever. I mean, I could imagine this could go on for years and years and years while the courts sort of decide what are all these new rights. And there really is no reason for it, because we have a common law that provides all kinds of benefits. The last point I would make, and I think this is really important, it particularly applies to police officers or corrections officers, but arguably to others. Remember this. Police officers are the bearer of bad news. That's almost always what they're doing when they're having an encounter with somebody. They're the bearer of bad news. So even, in the most minor thing, you're going down, this has happened to me. You're going down the highway and you're going too fast. I mean, I can remember I went out to visit my daughter in Montana, and I was driving home, and I was driving through Billings, and I was going too fast. And the police pulled me over. The officer was completely professional. There was no, but I was a little annoyed. I mean, he treated me with complete respect, but you're a little annoyed. She says, I'm just wasting my time a little bit, and I wish that I wasn't doing anything dangerous, but I was speeding. There's no question that I was. Just, imagine that that's your job all the time, to be the bearer of bad news. A lot of people don't react well to bad news. And so police officers are put in situations where, where it's very easy for someone to come and bring a lawsuit because they're pissed, frankly, excuse my language, but that's it. Even though, because they don't like being told that, that they don't like being caught, being brought to their attention that they've done something wrong. And I think that's unfortunately happens all too often, and this would make that even worse. As Representative Alexander pointed out, when the police have really done something wrong, it's beyond simply an error of judgment or something like that. They can and are held responsible, and I think that the current law is adequate to do that. So for those reasons, with great respect for Representative Smith, I will vote ITL on this bill. Anybody else have anything that they wish to say? All right, I guess we're ready for a vote on House Bill 647. The motion before us is ITL, and I would ask the clerk to please call the roll.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman. Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Kutab votes yes. Rep. Perez.
Yes.
Rep. Smith.
No.
Rep. Horrigan. He's not here. Rep. DiLorenzo.
No.
Rep. Eaton.
No.
Rep. Page. Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
The motion passes 16-3-1.
All right, and so Representative Alexander, I think you're not quite busy enough for this. So could we ask you to write the report? All right, and will there be a minority report?
There will be a minority report.
All right, by Representative Smith.
Representative Smith.
All right, thank you.
I'll speak for the rest.
16.
All right.
But there
All right.
probably will not be a debate on the bill.
No, that's fine. That's fine. I understand.
I'm happy to do it. Happy to.
You can't put it on the consent calendar with three.
Right, no, that's, yeah. All right, let me turn then to, HB 343, and I see Attorney Rosenberg is in the back, and we've kept her waiting here all day for something that I think is, I hope we're gonna be in large agreement on, and I apologize for that. But Representative Kutab, I recognize you for, a motion.
I move ought to pass with amendment 97H.
Right. Is there a second?
I'll second, Mr. Chair.
Second by Representative Alexander. All right, Representative Kutab, would you like to speak to your motion?
So I believe that this bill speaks to Free Britney. If somebody wants to be released from their guardianship, they need to have records to be able to show. Sorry, Rep. Alexander. He totally gave us that line. I will give credit where credit's due. So if somebody wants to be released from their guardianship, they need to be able to show that they're at a capacity to be able to do so. And in order to do that, oftentimes they need their medical records. And so if we're prohibiting them from getting them, then their guardian can kind of keep hold even when it may not necessarily be appropriate. So I think that it's very important that we pass this bill. And I want to point out that this bill also does allow for if the court, for whatever reason, did deem that the person perhaps just really isn't fit to have their medical records and needs to be prevented from having them because for whatever reason it may prevent, a possible may present a possible danger. It does allow for the court to ahead of time with intent to restrict it. Thank you.
All right. Anyone else wish to be heard on the amendment to HB 343? Are we ready for the question on the amendment? And do we need, unless anyone asks for a roll call, I would propose to do it by voice vote. All right. So we're ready for the question. All those in favor of amendment, is it 97? Yes, Amendment 97 to House Bill 343, please say aye. Aye. Any opposed? All right, motion carries unanimously. Now we're on to the main motion, which is ought to pass as amended. Do I have a motion? Oh, I thought that was on the amendment.
Yeah, but
Oh.
the motion was of TPA.
Oh, okay, all right, so that's fine, as long as everybody agreed we have the proper motion, all right. So anybody want to speak to the main bill as now amended? Seeing none, I'd ask the clerk to call the roll, please.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Kutab votes yes. Rep. Perez.
Yes.
Rep. Smith. Morgan's not here. Rep. DiLorenzo.
Yes.
Rep. Eaton.
Yes.
Rep. Page. Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
Yes.
Motion passes unanimously 19 with one no vote.
Exception, I would think it should go on.
I agree. Anybody have any problem with that? All right, consent. All right, last but not least, House Bill 396. Yes.
I just would like to say that I submitted a last-minute amendment to this bill, which was passed to you. And I want to let you know that the only change in this amendment was that on page 2, line 4, the word "when permitted" was eliminated. And on line 5, "when permitted" was eliminated. It does not, it doesn't change the amended analysis of this bill, but those words were eliminated. And that is amendment 2023-0441H.
Right, 0441H. Okay. Does everybody have that?
Yep, I gave
Yeah.
you.
Oh, you gave, yep. Oh, wait a minute.
Thank you.
So. Maybe it was already, oh, wait a minute, let me, hang on. 441.
0441H.
Yep, wait a
Today,
minute.
it's got today's date at the top and my name at the top. Oh,
I don't, I've got my copy, but I don't, I mean, does everybody have that? Everybody has it, all right,
Yeah.
all right. So, and so that's the only change?
that is the only change to it at all. There's no other changes in it. Those two words were taken away twice.
Okay.
Mr. Chair, and a motion has not yet been made, only that just the announcement that there is an amendment. So I would move that we adopt, that we, House Bill 396 ought to pass with amendment 0441H.
All right, is there a second?
I second the motion.
All right, so, Representative Greason, do you wish to speak to the motion, or I'm not sure who's gonna speak to it there. Somebody wish to speak to it?
This bill just does one thing. It clarifies that the state is not absolutely forbidden from using biological sex to differentiate between groups of people. We should think long and hard about the implications of our vote today. This bill should be a common sense clarification of current law. By voting against this bill today, we would be sending the message that the public entities are completely banned from having any separation at all for biological women, period. I think the fact that this bill is controversial should ask us whether or not we are out of touch with the majority of our constituents from both parties. All of us have seen many examples of written testimony, over 100, and emails from all ages of individuals who are concerned about girls being bullied and their privacy and dignity is violated by biological males in locker rooms and bathrooms around the state. Look at Milford. Those parents and children spoke up. How many haven't out of fear of repercussions? The people deserve to have their voices heard. I have been to multiple events over the past 2 weeks, and I have spoken and asked about this bill at every one of them. People deserve to have their voices heard. This bill at least deserves a debate in the people's house, and I hope you will vote to recommend to pass. One grandfather just last evening said, and I quote, "We cannot provide equity for 100% of the people 100% of the time. That is impossible. We must provide safety for the majority and protect their rights to privacy in sensitive spaces." End quote. Supporting this bill does not make me against any of the LGBTQ community. It makes me a person who has asked and read and feels that I am working for the majority of the people I represent and who is willing to stand my ground for them and my informed beliefs. I also know that when testifying for House Bill 104 yesterday was being done, there was a transgender that was sitting next to someone, and the person next to them said, "I understand that you want to use the girls' room, but how are you going to feel if the entire football team comes walking into the girls' room when you're there? Wouldn't that make you uncomfortable?" Thank you.
Anyone else wish to be heard? Representative Greason.
Thank you, Mr. Chair. We spent an awful lot of time during the hearing on this bill trying to define words. When words don't have definition, and if words are allowed to change definition too frequently, then the whole function of society, the whole foundation of society crumbles. Government can't enforce laws because words don't have any meanings. Government can't protect rights when words don't even have meaning anymore. And so this is a very complex issue, but we have a bill that protects as many people as it can possibly. You're always going to find some exception to anything that we ever try to do, but this is actually protecting as many people as possible in the most respectful of ways.
Thank you, Representative Grease. Representative Tur, oh, I'm sorry, Representative Smith.
Thank you. When I was young, which was a very long time ago, I was on a ferry with my family, and we were going from Newport News to someplace else. I'm darned if I can remember where. I must be having a senior moment. And I saw something that, having grown up to that stage in New York, I had never seen before. There was a sign on the door of one of the rooms that said, "Colored people only." And I had no idea what that meant. And that sign was there because in that community at that time, which was before Brown versus Board, which was before the Civil Rights Act, that sign was put there because people thought that would protect the majority of people from having to do, meaning white, to having to do anything with people of color. And I was about 10 at the time, and that was probably when I decided that there was something wrong and that I had to do something about it. I was 10. I hate to tell, well, I'll tell you how many years ago I was 10. I was 10 71 years ago, except in 10 days it would be 72 years ago. And ever since then, as a child and as an adult, I have tried as hard as I could to remember that in a true democracy, we had to protect the rights of the minority. Because if we only cared about the majority, if we only paid attention to the majority, we would not be honoring the basic documents that brought us together. When my husband and I were married, we were of the same religion, but we chose to be married by a judge because we believed that the Constitution stood in honor of all that we cared about in terms of how we were to live in a society. This bill is designed to deny the rights of individuals who have made choices that I can't understand, and I'm sure many of you can understand. It is an alien world to me. It is nothing that I had been part of, but I look at my colleagues here in the legislature who are in fact transgender and know how they are entitled to the same protections that all the rest of us are entitled to. And this bill, to me, is a violation of what makes us so special as a country, recognizing that majority rules, but we have an obligation to the minority, whether they're of a different race, a different religion, or if their sexual orientation is something that is not understandable to us, but that doesn't give us the right to deny their right to be able to live in a free society. And so I will be opposing OTPA, I don't think we can do any amendment that can make this acceptable. Thank you.
Yes, Representative Tur, I think you were next.
Yeah, and I have many issues with the bill, and I support what Representative Smith just said. Although I think stepping back a level from sort of the underlying implications, I think this is just a very dangerous bill for the reason I asked multiple of our witnesses on the day that this was heard. We're applying a definition. We're applying the definition of biological sex. We are allowing that there are only two of them, and we're basically saying any public entity can use biological sex undefined to make any form of rule or separation. I think the idea of putting down a law that sweeping that applies to everyone in the country, and even setting aside the ideas of multiple definitions beyond two biological sexes, setting that aside, the idea of passing a law that says any public entity can use its own definition of biological sex in an undefined way. We heard, I believe Representative Kutab listed several different parameters along which biological sex can be defined. And it just opens a door to basically any municipality choosing any definition that doesn't even have to conform with, I believe, the four that were mentioned, and saying that's biological sex and therefore applying a standard. I just think you can't have a law that establishes a definition and then fails to define the definition. It's just a wide open invitation to rampant, misuse.
Yes, Representative Horrigan.
Sorry, I apologize. I had to introduce a bill in another committee. Pretty controversial, but not as controversial as this one. There is no definite definition of biological sex. I don't think it's a particularly useful exercise to doing, because there's a lot more than just the X and Y chromosomes that go into it. Some people have, some people are intersex. Some people have, there's some people of XX chromosomes who develop into males. There's some who have XYs that develop into female. It has a lot more than do with just their chromosomes. Some people are like mosaics of like one or more egg will fertilize, and then they'll combine into one embryo and then a fetus. And there's lots of people with unambiguous genitalia, and then lots of people who are just very androgynous. I think we really, I think your gender identity and your gender expression that's just as biological as anything else that's involved. It's probably more biological than, those chromosomes in your DNA we hear so much about. And I think also bringing forward his bill this time, there's just a lot of uproar over it. There's a lot of I think there'd be a lot of collateral damage. There's like a situation at a local school, which this bill is somehow gotten tied to. I don't think there's anything this bill can do to help with that situation, especially since that situation already happened before the bill was introduced, before we had the debate on the bill. So I think, I think the best thing to do is just leave this be. And certainly trans people, they're more worried than, school board member Milford and anyone else. They're walking on eggshells all the time. They're afraid of much worse things than being sued. They're afraid of being harassed, attacked, sometimes, many times even murdered. So I think we should live and let live, and I think we should not pass this bill. So,
Right.
Thanks.
Representative Perez.
I understand exactly. I lived in Virginia in the 50s. I'm 100% Italian. I have half my Italian family is very olive-skinned, half are light like me. I had a cousin in the 50s that came to visit us, and she was not allowed in the movie theater because she was dark-skinned and it was summertime. So I understand the black, but you can tell if a person is of color. You cannot tell the biological sex of someone who is transgendered. What concerns me, and I understand them and I understand their rights, but I want to know, this is happening in schools everywhere. Most schools now allow boys and girls to go into any bathroom. I know it's true in Wyndham. I know it's true in Dover, Milford, Londonderry. Most schools are allowing boys and girls in any bathroom. And it is out of control because you have young kids who won't go to the bathroom in school and wait till they get home. Horrible problems with that. But what I want to know is where the rights are of a little boy using the urinal and not wanting a girl to be walking in, and where are the rights of the girls being able to go into the locker room and change, or into the bathroom without having a male walking in, whether it be a transgender male or any male. We're allowing any males to come walking in, any males. And my final thing on this is, does this not open the door to pedophiles? If you're allowing a male to come into a woman's room in a public building, and I'm going to dress up like a girl that day, it opens the door to pedophiles. And I have a real problem with that, having young grandchildren. And let me tell you a story about the past. When I was born Christina Anna Maria Ferranti, Christina. That was changed to Kristine, legally changed when I was a couple years old, because of headlines that said Christine back in the 50s. Do you know who that was? That was Christine Jorgensen. That was the first sex change operation. It was so upsetting to my old-fashioned Italian Catholic family that they literally changed my name to be spelled differently. We have come a long, long way. I have respect for people who choose to do this. I have respect for them to putting themselves for it. But I also have respect for the fact that I have a right as a female to go into a bathroom, and I have a respect to my privacy.
Sorry, Representative Alexander and then Representative Kutel.
Thank you, Mr. Chair. So I voted against a bill similar to this last term. I think there were significant language issues with it. 396 as it is right here without the amendment, I think there's a lot of language problems with it. I think it was clear the New Hampshire Attorney General came in and outlined his concerns with it, among others. I believe the amendment significantly improves it. So, I mean, it just says the state has a fundamental interest in biological sex, but it keeps it narrow, right? It only says in these specific situations. It doesn't force anybody to do anything. It just says that there's an interest and that the state may at some point use that in 3 situations: in lavatories, athletic events, in mental hospitals and prisons. So I'm voting, I like the amendment. I'm voting for it. Thank you.
Representative Kutel.
I don't like that biological sex is not defined in this bill. However, I would like to point out that in Milford, they did make the decision to separate the bathrooms anyway, even in the absence of this bill. They made the decision to do that, and then they later rescinded it. So I do feel that it can already happen. And so even for those against this bill, and I'm not saying that I agree with it, even for those against, I would say perhaps at least it's limiting the fact that it can only be used for these 3 purposes. And we're not saying right now, it's kind of, we're not saying you can't use it for anything. And so it's already being allowed to be used for things. And so if it's being more specific that it can only be used for those 3 things, I think in some ways perhaps it actually is offering a little bit of protection.
So I guess, I'm sorry, did you want to say something, Representative Devine? Yes, please.
After listening to all the testimony, I understand that people have their, concerns. Personally, I feel like this bill is just way off base. Even the, respectfully, the amendment, even though I understand it. My question would be, is how would you enforce something like this on, say, the school, elementary school level, the middle school level, the high school level. Then you're getting into the college level. Then you're getting into whatever beyond that in athletics, say, within this state. How is something like that enforced? I mean, to me, there's nothing in here that would suggest that, other than leaving it to private entities or public entities. And there would be direct there would be, it just to me would be extreme discrimination that would be unconstitutional to anybody that is biologically, sexually labeled within two categories, male and female, or intersex. And I'm like, how does that work if you have a bill like this that's going to pass? There's just no mandating. I think, you know, it should stay in the schools. You know, like the schools could monitor those bathrooms all on their own. But nobody wants to do it. The parents are the ones that are up and, you know, having problems with this. I don't, we didn't hear any testimony from kids, but we did get one testimony that came in from a transgender girl online through email. And, you know, she's doing everything appropriately. How can anybody, like, sit there and tell, like, some parent that their kid is born a certain way? Oh, and that's what's happening here.
Hang on, anybody else that hasn't spoken already wants to speak? Representative Andrews.
Thank you, Mr. Chair. I am a person that believes in live and let live. Everybody should be protected. I agree with the Representative Perez and everything she said, and I believe in this bill. When I go into a bathroom and it's labeled women's, and that's the one I choose, I do not want to come out of a stall and have some man standing there, and it can happen the way things are today. In schools, every child should be protected, and it's up to us adults to protect them because they have no one else. Now, when you start talking or speaking about students that might be modest and don't want the opposite sex, et cetera, in the same bathroom with them, they have that right just as much as anyone else does. Someone, you know, this whole situation is something somebody's got to have figure out. If somebody's transgender, they should have their rights. LGBT, they should have their rights. But the child that is modest and doesn't want the other sex in the same bathroom with them, their rights need to be protected also. Thank you.
All right. Anybody else? Representative Turer.
Yeah, just one more thing. The first question, I believe this modifies a piece of law around changing public documents that have sex listed. First,
Well, not the amendment. The amendment doesn't. But
okay,
the original bill did. You're right, but the amendment does not have anything to.
Okay, I guess I'll reserve that for. I mean, the amendment doesn't change in that regard, but yes, I mean let me just hold that thought and come back to it.
Representative Horrigan.
Thank you. The talk about schools and bathrooms resonates with me because I was, and I'm probably not the only kid I was harassed. There's a lot of harassment and bullying that takes place in bathrooms and locker rooms. But in my case, that was all entirely by, almost entirely by boys my own age who are very, cis males, as they call them. So there's no ambiguity about their gender identity, their gender expression. They're just being jerks, and a lot of their jerkiness ended up being kind of sexually tinged. I don't know if any of them were in fact gay or anything. So and then another time when I was probably in my early teens, about 14 or 15, somebody did try to sexually assault me in a men's room. It was a older man, once again presenting as a man, as far as you know, entirely cis male, had the XY chromosomes and everything. So this kind of thing happens. You're not preventing this from happening anyway. It's and institutions do have the right to anybody who harasses or assaults anybody in the bathroom is in trouble. And I don't think I ever barged into a ladies' room, but I hear they're not that much different than men's room, a little bit nicer sometimes. But I never met a transgender person I knew to be transgender until I was in college, and well, he or she was a pretty outrageous person, but I don't really remember. She was not out to I don't remember ever like assaulting anybody. You know, she was a pretty normal. I don't know whether call her a normal, she's a very exuberant person, but she was like certainly not out to harass anybody. She was just out to have a good time, like the rest of us, and get through life without going crazy. So that's So I feel this bill is unnecessary, and I do worry, frankly, about this transgender kid in Milford. I guess I'll use the they pronoun form. Obviously, if we believe what her friend's mother said, and her mother, I'm sure, believed that what she said was true and was acting out of love, that was one kid allegedly acting like a jerk. And even though we don't know who that kid was or any details other than what we heard, I'm sure the other people in school know about him. So and the other people in their town, not that I condone what they allegedly did, but it's got to be what pretty horrendous what that child's family and and the child himself are living through. So that's like, I'm sure it's like not fair. And then one of the things to worry about with it's a debate and hoping to making worse is we're probably making things a lot worse for that one, that one kid and their friends in Milford. So they're being obviously probably being ostracized, harassed, and who knows what else. As I said, I'm sure most people in town have a good idea which kid this is. So it's not really. So it feels a little bit unfair to be legislating on anecdote I hate anyway, but legislating on the basis of that one anecdote I really hate. And I know there's more to it than that, but I think just the timing of this is very bad. So I would be against this bill anyway, but especially against this bill at this time while this controversy is going on in the otherwise very peaceful little community of Milford, one of the most beautiful towns in New Hampshire. But there's something ugly going on there, and I don't want to make it any uglier. And I'm afraid this bill would make it worse. So because.
All right. Representative Perez.
This is going on in every school, every single school, and it is not just transgender. First of all, personally, I don't think it should be in the schools at all. You ask how it will be enforced, just like it's always been enforced. Johnny, you use the boys' room. Susie, you use the girls' room. Most schools in New Hampshire, because of the existing laws, have put into place that boys and girls can use any bathroom they want, okay? Any bathroom they want. Be aware of that. It is true. It's an issue in the elementary schools because Susie doesn't want to go into the bathroom in the 3rd grade and have Johnny walk in. But the problems that are happening at the high school is you have non-transgender boys that are allowed to go into the girls' room. And just like boys always did, go peek into the girls' locker room. But it's more than that. I can go into that bathroom because it is allowed in my school district. That is what's happening. Privacy, as an adult, you can protect yourself. As an adult, you can protect yourself. As a child, they cannot protect themselves. They can't protect themselves from being put into horribly awkward positions. And that is exactly what's happening. And if we don't want to protect the children, who are we going to? You wonder why parents weren't here? Parents are not here because they are afraid of repercussions. I was on a school board when my now 45-year-old daughter was in the 6th grade. I voted against things, okay? Her teacher in the 6th grade abused her, would not let her go to the bathroom to the point where she ended up peeing her pants in the 6th grade. My daughter in her 40s now still reminds me of that. Things happen. We need to protect our children. If you want to have anybody in the bathroom as an adult here anywhere, that's fine. But we need a law that's going to protect young people. And this law is the only law that's going to protect them. Schools are having problems. High schools are having big problems. They're being covered up. You can go to the superintendent. Parents have gone and complained. Kids are afraid there'll be repercussions from them.
All right, so, Representative Stapleton, yeah.
Thank you, Mr. Chair. My emails are running, I don't know, 40 to 50, maybe higher to 1 in support of this bill. There is a sense of fear and apprehension out there on the part of parents, and I think that comes from the fact that the children are upset and maybe reporting and relating this stuff to parents. Traditional anatomical separation for decency, safety, and privacy we've had for hundreds of years, if not for thousands of years. This is a orderly society tradition. And I have to ask, is our culture departing from good sense? And I would say, yes, it is. And we're getting off on tangents and extremes. And I think it's time to restore sanity here. And I'm going to support the amendment, which fixes some problems, and the bill, because I think we need to have restored order and common good sense back into our culture and stop the license to bad actors and stem the aura of fear and apprehension.
So, Representative Testerman.
I agree with you completely. We've got a movement in this state for schools, independence of schools, and the state helping provide the parents with some money so they can go to private schools, to religious schools, but or do homeschooling. And a lot of it has to do with the parents and the children not being comfortable with what's going on in the schools. I was on the school board until recently. Yeah, you could try to find out why all this was happening, and everything just sort of got hidden behind a screen. This is not right. You can talk about there's a wonderful way to be transgender, there's a wonderful way to be this or be that, but there is the right and there's the wrong. And there are some alternatives, and if you'd like to use those alternatives, be my guest. But this is not, doing something like this is not the way to do it. And if we have to do some correction in the schools, so be it. And having 1 or 2% of the kids unhappy with whether they can go to a particular bathroom or not in school, life's rough. If you pick some alternative to your sexuality, you need to learn. There is something to pay for it.
So I guess what I would like to say on this is this. First of all, I haven't moved to introduce my amendment, which is virtually the same as Representative Perez's amendment, except for the words "when permitted." I know that the removal of those words likely came because my friend who's in the audience, Mr. Hewitt, and the Cornerstone Group thinks that having that language in there is a bad idea. I have to say I'm not sure I agree with that. I mean, whether you put that language in there or not, the effect of the language is to allow some 3 particular circumstances when classification on the basis of biological sex is permitted. I guess what I would say is this. I recognize that people on both sides have sort of strong views on this, and I respect the views of everyone who's spoken here, just as I thought the people who testified at our hearing on both sides were good people whose views I respected, and I really felt that I learned something from the hearing. What I would emphasize to you in support of this amendment is this. first of all, recognize this is a very narrow amendment. One of the reasons that I first sort of thought about coming up with an amendment like this was I was concerned that the language in the original bill had too much wiggle room. It was too likely that it could be applied to other circumstances. So what I tried to do is I basically said, look, what are the areas where people are complaining that there's something wrong in this area? Are people saying, you know, we should be able to discriminate against transgender people in employment, in housing, in any of the other things that are the subject of the Civil Rights Act? No, I haven't heard anybody say, you know, we got to stop allowing transgender people to be able to be hired in this business or that business, or they shouldn't be allowed to rent an apartment, or any of the other things that are the subject of what we would normally think are the Civil Rights Acts. People have concerns in 3 specific areas where it seems to me there really is a basis for the concern. People are saying, wait a minute, a locker room that is used by multiple persons, or a lavatory that's used by multiple persons, that's the kind of thing where there really is a strong privacy interest not to want to have somebody who is of the other biological sex in that facility. The same with sports, with particular sports, not all sports. You know, as I think I've mentioned to you before, my hobby is target shooting. When I first started, when I was 14 years old, and for years and years and years, there was a women's division because there weren't that many women shooters, and so there was a women's division. Well, they stopped that probably about 10 years ago because there's a lot more women shooters now, and more importantly, they beat the men regularly because shooting is not, it's not something of physical strength makes a lot of difference. So there's no more women's division in shooting because they don't. It's just outmoded. And as I said, the last 2 Olympians in rifle shooting from the United States, I believe, were women. But anyway, I'm getting sidetracked here. I try to cover only the 3 areas where I thought there really is a valid basis to say classification based on biological sex makes sense. I would also note this is in no way a mandate. This bill doesn't say you shall do this. It just says you governmental entities are permitted to do this if you want to. The last point that I would make on this is I think this is really important. Remember this: separate but equal. Although we absolutely reject that in the area of racial discrimination, as we should, we don't reject that in the area of sexual discrimination. If that were the case, if separate but equal could not be allowed, you couldn't have, put transgenders aside. You couldn't say that we have for completely straight people. So a boy could say, I want to go into the girls' bathroom. You're discriminating against me if you have separate bathrooms. It has to be just one that everybody gets to go into. Or a girl could say the same thing. We don't say that. If separate but equal couldn't be allowed in circumstance, Title IX of the federal Title IX with dealing with federal funding for sports programs, that would be a violation of the Constitution, because in fact in Title IX, there is a sort of separate but equal. You have a male, the varsity football team. That doesn't mean that women are allowed to play on the varsity football team. It means that you have to offer other equal opportunities for women to participate in sports. So I guess what I would say is there are some areas that sexual classifications are different from racial classifications. And there are some very narrow circumstances in which I think, and I suspect, that most people would agree that the classifications are allowed. I would note at the constitutional level, remember the Bostock case, remember, was the 5-4 decision of the Supreme Court that dealt with transgender issues. That dealt with it in the context of employment. The court has not dealt with transgender issues in these specific contexts, and as I understand it, there is a split in the circuits about the constitutional question about whether some circuits have said this is okay, and I think there are some circuits have raised questions in various contexts. I don't know that there's any that has, that has dealt with a statute that sort of deals with all these three circumstances. So to me, I think that this amendment is narrow, it's not mandatory, and I think it does address areas of legitimate concerns by people who are not, homophobic or transgender phobic or anything like that. They just have legitimate concerns about privacy rights in the case of lavatories and other things, safety concerns in the case of facilities of incarceration or mental health institutions, that kind of thing, and fairness in the case of sporting, particular types of sports where everybody can kind of recognize that strength or endurance or speed or whatever gives biological males the advantage. And the last point I'll make, and then I'll shut up, is with regard to the issue of biological sex is not, it's too vague. I'm sorry, I have to say respectfully, really, you can't, if somebody asks you, is somebody in this room, are you a man or a woman? Really? You can't answer that question. I think that, this really isn't rocket science. It's law, and we make decisions based on our common experience. And I guess I would say that I think most people understand how to distinguish between men and women. And the very last point I'll say is this. It strikes me that most of the people that we heard here as witnesses, they weren't coming in here and trying to sort of hide their gender. It seems to me that most of the people that regard themselves as transgender, they're not trying to hide that from anybody. They say this is what I regard myself as. I'm transitioning to be a male, or I'm transitioning to be a female, or whatever. So I don't think that the sort of how trying to. Nobody is suggesting that the school authorities or whatever should be able to, do a, drop trow check. I'm not suggesting that for a moment. Anyway, that's it. Thank you. I think Representative Smith.
I'm trying to decide whether we're just beating a dead horse here and whether we should just go on. But isn't the last point you made exactly what at least is concerning me? That the people who came and testified weren't in any way denying what they are doing, that they are transitioning from one sex to another. And that is true. They're not denying it. What they are saying is, does that therefore mean that they don't have the rights that are afforded to everyone else in the country? Think about it in a different way. Think about what we know has happened over the years, that there were people, probably a majority of people, who did not want to have to go into a restroom with someone of color because somehow they felt that that would compromise their own integrity. Think of the people who, and it's still happening, who do not want to be associated with people of a different religion, whether that religion is Jewish or whether that religion is Muslim. Probably not Christian, because we live in a country that is majority Christian. But we certainly know that people could be, I'm not going to go there. Uh, the fact that some people are offended, I think just shows that in 2023, we in this country are living with values that are more reflective of the Victorian era than of today. Other countries don't have this problem. Other countries consider sexuality to be a normal part of who somebody is, and however they define that. And we don't make a big deal out of it. And we shouldn't be making a big deal out of that, because if we were to pass this legislation, we are saying that people who are transitioning or who have transitioned, including people in this very body, really don't have the same rights as the rest of us, because it gets other people nervous, and that is wrong. Thank you. I'm sorry. I don't want to.
Yeah, well, so Representative Manos.
Thank you, Mr. Chair. I just wanted to enter into a dialogue based on some of what you said. So I'm looking at the amendment, and Roman numeral paragraph 3 talks about prisons, houses of correction, and then it goes on. Right. And I just wanted to raise the point that we heard, I believe it was through the AGA, that the Departments of Corrections, that the Department of Correction and the prisons make individualized judgments on how they are going to separate the population. And it was my understanding from the AGA's testimony, I believe that's where it came from, that the state wasn't having a problem about this. And so I want to enter into a dialogue about why and we didn't hear from any other state agency, the Department of Mental Health or any other, the juvenile correction system. We didn't hear from any other state agency about having this problem in their making administrative decisions about how to house or their populations. So that's one point I wanted to raise. The other point is in paragraph, it's Roman numeral 2, but it's the first sentence under 1 and 2, lines 1 and 2 on page 2. The legislature finds that permitting classification of persons based upon biological sex serves this compelling state interest, and then goes on to describe the 3 circumstances. And the fact that the amendment states that this serves compelling state interests doesn't necessarily make it so. A court would have to decide that. And then again, I would raise the point that you also raised about the split in circuit decisions. And I also don't know whether those cases are on all fours with this proposed amendment and the underlying bill. But the point here is that these cases are coming forward. There is a split in circuits. I haven't looked at those opinions, so I don't want to offer a position on that. But this will end up being addressed by the U.S. Supreme Court. And I think it's inexpedient to legislate in this area until we know how those issues are going to be decided by courts. But I just want to emphasize again that stating that something is a compelling state interest doesn't make it so.
Representative Tur and then Representative Staples.
Yeah, so I'm going to revisit what I started to say earlier. I'm not sure if we're talking about the amendment specifically at this point or whether we're talking about the broader bill. So, I'll just say it and hopefully it fits in the context. What I started to say was this bill alters a section under 260.21 for identification cards under the Department of Motor Vehicles. First question I asked Representative Kofalt, thank you, was, does this pertain at all to either birth certificates or driver's licenses? And he said no. this is separate from that. What's marked on your driver's license or your birth certificate is not what this is trying to do, and that's not what defines biological sex. So I guess that's my first point, is I think it's kind of odd to put a piece of legislation in a section, and I'll read the section that is here under 26021. Says the identification card shall bear the name, address, date of birth, blood type, optional, and then not optional, gender indicated as M for male, F for female, or X for other. Birth certificates have that too. So the simple classifications that I will call not biological, that already exist and are written into the law that we're trying to add to, basically create definitions that are, I think, when I hear Representative Perez and Representative Andrews talk, more in line with what I believe they're talking about. If we have new technology, going back to Representative Stapleton, we have new technology that didn't exist back in the day, I guess, to change people's physical characteristics or outward characteristics to match their beliefs and their identity in a way that actually defies exactly what we're talking about. So if you said biological sex, I don't know if you'd concede that it is established at birth, but if it is, by whatever definition, then the person who is transitioning and who was born a female, but now has a beard and, very male characteristics, or vice versa, if we go to biological sex, as opposed to the kind of sex that's defined on the documents in the section of the law that we're trying to modify, then we are basically saying that's the imposition that the public entity is allowed to make. They're allowed to say the bathroom is for biological males. And so someone who was born a biological male, but has transitioned and now has sexual characteristics associated with females, would go into that bathroom, right? I mean, that's, I don't know if I'm making this clear, but I feel like both the portion of the law that we are working with and the applicability of this, if it actually were to be put into practice, both run contrary to, I think, the things that Representative, sorry to mischaracterize if I am, but what I think I heard Representative Perez and Representative Andrews say, which is, would you or would you not want to force there to be a person with a beard in the ladies' room? Biologically, that person probably is still technically at some level the sex they were born to, but they don't look that way. And so it's not that easy to tell. It's not a slam dunk. And I feel like this would actually undermine the goals of providing comfort both to the person who feels that they belong in the men's room because they look like a male, and the other males that are in the men's room because they think that the people that they want to be surrounded by would best be males. Do you understand why I'm raising this point, both in terms of where it is in the law and in terms of the applicability of the law, setting aside my previous objections to not defining what biological sex is, because this is where it actually hits the road.
Mr. Chair, we have some very thoughtful, intelligent, bright people on this committee who are very interested in discussing a very complex issue. I'm one of them, and I probably talk way too much. But I'm not sure at this point that we are convincing anyone to change his or her view, and therefore, if you would not object, I would like to suggest that we move the question.
No, I think you make a very valid point, Representative Smith, and I think, yeah, I think I think we really have had a full debate on this. That would be, so the motion before us is the motion of ought to pass as amended with Representative Perez's amendment 2023-441H, and that's the question before us. So I guess I'd like to ask Representative Kutov to do a roll call on that amendment.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason.
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. Smith, Rep. Horrigan,
No.
Rep. DiLorenzo,
No.
Rep. Eaton,
No.
Rep. Page,
No.
Rep. Macbeth,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Chairman Lynn.
Yes.
Motion fails 10 to 10.
TPA fails 10-10. All right.
Mr. Chair, I'd like to make a motion.
Yes.
I'd like to move that we retain Haskell Free Market.
Second.
All right, seconded by Representative Eaton. Is that right? Yes. All right. Would you like to speak to your motion?
To reach an agreement. I think perhaps we could if we kept this bill for 10 years or so.
All right, anyone else wish to speak to this? So I guess what I would say on this, I respect what Representative Smith, I respect Representative Smith's motion. I tend to think that this is a matter we ought to have, it ought to go to the floor without, I suspect what will happen is if this motion fails, there'll be a motion of ITL, which I expect will also fail, and that will mean the bill will go to the floor without recommendation. I actually think that might be a better resolution. This is an issue that has a lot of different, has arguments on both sides, which I think the arguments on my side are better, but I respect the arguments on the other side. And so I guess what I'm saying is I don't really think that anything is going to change by the fall that would make us, in other words, if somebody were suggesting, look, if you just did this, tweaked this or did that, we could come to an agreement, but it doesn't sound like that's the case. So we're going to be, in the fall, we're going to be right where we are now. I think I'd rather have it go to the floor and, without recommendation. But I think Representative Macbeth, you were.
Thank you, because I haven't spoken on this bill yet.
Sure,
so,
of course.
I wanted to say that it goes to what my colleague Tour said and also Smith. I mean, I do believe in civil rights. And one of the comments that was made was, you could tell the people that were testifying here, they were going through transition, but they weren't hiding their sex, and they were, you could guess it. Well, I don't believe that. For me, I would never try to guess someone's sex because the sexes aren't just male and female. Just like Representative Tour pointed out, on our birth certificates and on our driver's license, we're allowed to say other. There are several other sexes, and this bill completely negates that. And the testimony that you think that you could guess, I don't guess because you're wrong a lot of times, however someone is presenting. There are more than two sexes, and I really ask people, if you aren't aware of that, or people are claiming they're not just always in transition and in between male and female, there are other genders. So I need to say that because being silent is, I think, not putting all the facts out.
So may I just ask a question, Representative? So I appreciate what you've said, but do you think that what you said is a reason to retain as opposed to having it go to the floor without a recommendation?
Absolutely, because I think that this bill defines gender as two, and we have other our driver's license and our statistics, what is it called? Essential, I'm sorry, I'm tired. The vital statistics, where they say, no, it's not just two, there's an other. And the other has got more facets in it that I can't educate you on. I'm not educated on myself. So yes, I do feel that is a reason to retain this bill. Because we're going against other state law and other state, what other state agencies have recognized is that sex is not just male and female.
Right, I mean, sorry, I don't mean to argue with, all I'm saying is, wouldn't what you just said be a reason to have a vote of ITL in your view, and then it would, it would go to the floor with no recommendation, and then the legislature would decide now as opposed to in the fall which side they agree with.
I don't think so, because this is something that requires a lot of thought. I mean, we all have given a lot of thought, thoughtful consideration, not just a knee-jerk fear of certain things that can be stirred up easily. So, no, I don't think sending it on the floor is what's best. I think retaining this bill is best, and looking at, how we should push it forward to really, if we want to protect people's civil rights and people's privacy, which are both very concerned to me, then let's figure out how we can do it.
All right, yes, I'm sorry, did somebody else, Representative Perez?
I understand saying that, wait, law cases, let's see. I'm not a lawyer. I'm a nurse, retired. This is too important right now because what is happening right now can't wait. How many times have we heard when we've had things happen in schools, school shootings, that they knew there was a problem, but yet they couldn't do anything. The police couldn't do anything until the law was broken. I'm not willing to wait. We have parents, we have children, we have adults that are having issues. They are being bullied, and I'm not saying by transgendered, but they are being put in awkward, uncomfortable situations on a day-to-day basis. I don't know how many of you have young grandchildren. Talk to them. Ask them how they feel about a boy going into the girls' room or a girl's going into the bathroom. I've spoken to some people who are extremely liberal compared to me, and they feel they do not want their daughters in a bathroom when any male, not just transgenders, any male can walk in. Any male. It's going to reach a point where, granted, we may have taken our little boys into the ladies' room when they were little. It's going to reach a point where we're going to go in with them no matter what age they are to protect them because they are children. We need to protect the children now. If you want to later change it and make it different for adults, but right now, because schools are allowing this, we need to protect the children. We are the only ones that are able to protect the children. They can't protect themselves. I worked in Boston. I saw abused children, horribly abused. Nobody was protecting them.
So I guess what Representative Smith,
Yeah, here I go again. I have 3 grandchildren, a 16-year-old girl and an 18 and a 21-year-old boy. I probably should say man, but I'll say boy. I call them the little ones, but one of them 6'5". They think we're completely out of touch with the world that they live in. They pay absolutely no attention, and one lives in Washington, one lives in Vail, Colorado, one's in college in Connecticut. They say they're all perfectly comfortable with this movement that none of us really understand, that makes no difference to them, and they laugh at how we get concerned. And I think that those reactions are much more in keeping with what most of people that age are. Their parents might not feel the same way, but they do. They let what happens, and it doesn't involve aggressive sexual behavior. We all know that there's aggressive sexual behavior that we are responsible for in this state because we have the Sununu Center where people whose salaries we pay have acted offensively and abusively to the kids who were most in need of kind care, understanding. We're part of that. We know that churches have experienced terrible situations where the very adults who young people are told to trust have violated that trust. This happens in the world. We can't pretend that it doesn't happen. What's we're talking about here is not in those categories. I still would like us to vote on my retention
All right.
motion.
Representative Page, you have been very quiet throughout this.
I
So
haven't said a thing, and I realize the hour, so I apologize to my colleagues. I joke with my friends that I have a minivan at home and I'm not afraid to use it. And I say that because when I drive 3 kids around in a minivan, I hear a lot. I try to be as quiet as I can so I can hear all of their concerns and what's going on at school. And I can only say I've never heard this as a concern. And in fact, to Representative Smith's point, what I do hear is actually the acceptance and the non-issue of this. It's not of top of mind. So I can only speak to my experience on that. But I do want to reiterate what Representative Macbeth said in terms, and also what Representative Smith said earlier with respect to committee work. It seems like this body operates well when the committees have the opportunity to digest things and think things through before they get to a full floor. So vote, and where emotions and not everything can be heard as quickly or as easily as possible as it can be in a committee. So that's why I think Representative Smith's motion to retain is a wise one.
Representative Stapleton.
I will oppose a retention. What are we doing with a retention? We're going to sequester this bill to our confines, denying timely open debate in the full House, in the greater audience. I don't think by retaining it, we're going to change many minds or develop solutions to a multi-complex problem and problems involved with all of this. So I believe we should run it through the motion process and send it to the House without a recommendation and let the greater body have a say at it, instead of just sequestering this bill to ourselves when we're not going to be able to do much with it.
All right. Anybody else wish to be? Yes, Representative Andrews.
Thank you, Mr. Chair. All right, I don't have any young children anymore, but I will protect any child. And my one question is that I keep asking myself, why have so many people emailed us to pass this bill if we don't have a problem? Thank you.
So has everybody had a chance to have their?
not.
Representative Dillon, do you have something to say?
Yes.
Oh, please,
Okay.
no, please go ahead.
Thank you, Mr. Chair. I am just really upset to hear about this bill. And I'm tired of listening to the anecdotes about the, quote, problem or issue. I would prefer to hear real evidence and not anecdotes to frame this conversation. My own personal feeling is that I don't believe in censorship as far as reading is concerned. And when I was probably at about 17 years old, I had read the autobiography of Christina Jorgensen, the first transgender woman who was out publicly. And since that time, I've kept an open mind, and I believe that our biological sexes go beyond male and female. There are variations, and there's no reason not to believe that. I'm tired of listening to the false theories and anecdotes. Thank you.
All right. Anyone else? All right, so seeing none, so the motion before us now is a motion to retain, and I would ask the clerk to call the roll, please.
Vice Chairman Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
Yes.
Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk votes no. Rep. Perez.
No.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Eaton. Rep. Page.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Chairman Lynn.
No.
Motion passes 11 to 9.
11 to 9, retain, passes. All right. All right. And so since it's being retained, we don't need a report. I think we're done. Does anybody have, is there anything else that we should discuss? So you know what? Yes, Representative Tripp.
Once again, back to the retained bills. Now, we're not going to do anything with these until next summer.
Until it's usually the fall. Representative Smith, it's usually the fall, wasn't it? That we,
Actually, the speaker probably would not let us do anything with retained bills until after the committee has done everything that they have to do on Senate bills.
Okay.
And so it could be about the time that we're beginning to do committees of conference, which would be in June, that
Okay.
we could start, and that would probably be the time that we could form the myriad committees that we might want to form, and could act on them during the summer and in the early fall. We'd have to act by some date, I guess the beginning of November usually.
okay. All right. Yes, Representative Manos?
I just wanted to clarify, we're not meeting tomorrow.
We're not meeting tomorrow. No, we're done. You know what I wanted? Can I just raise one issue just for your thought? If anybody knows now, it would be helpful to me. What I'm thinking is, we're gonna have hearings next week on the 15th and 16th on all of the abortion bills, basically. Then, what the following week, I would normally want to have us have an exec on those bills and the couple that we put over from, but right now the speaker is saying that we're going to have session on Wednesday and maybe Thursday of that week. So that we can't schedule that. What I was thinking of doing is scheduling our next executive session for Friday, February 24th, but that is the day before the week of sort of vacation. If you all are, or any
I know I
substantial
could not
amount,
be there.
then we're not gonna do it. Then we won't do it. We'll do it. We'll have I'll figure out a time.
We could do it on Monday or Tuesday if the other committees aren't using the room.
Yeah, that's a possibility. I'm just wondering if it gives us enough time after the hearings on that. But I won't, I won't do it. You have my commitment. I will not do it on Friday, and I will not do it the following week because people will be away, and I don't. So we'll do it. We'll do it early. We'll either do it Monday or Tuesday of that week, or we'll do it the week after the.
Okay.
Oh, you can't. All right. then.
Okay.
Did you say
Friday this-
we don't have a hearing tomorrow?
We do not. No, we're done. We don't have anything.
Oh, because I had it entered in my
Yeah,
calendar.
no, so did I. I didn't think we were going to get through it all, but we did. So I
Okay.
want to thank everyone. I know
Mr.
we've had
Chair,
issues.
before people leave, could I just make a suggestion?
Yeah.
7 o'clock, you know?
Well, you know what? Can we hang on one second, Representative Smith, please?
Before people leave, I just want to make a suggestion. We've exhausted ourselves tonight with important conversations, and I'm not sure we particularly changed anybody's mind. And that's not surprising. I would like to suggest that next week on our hearings on Wednesday and Thursday, which are very, very important to the many people who are going to come to talk to us, we might want to consider not asking questions of those people who come and want to talk to us, and we just listen to them and hear what they have to say, rather than, and resist the temptation to get involved in what might be debates, so to speak. I see representatives nodding, and I just, obviously, that's not a dictate in any way. I just would suggest that people think about
Yeah,
that.
no, I
And
think I-
sometimes questions can be challenging in the way they're put forth.
Yeah, no,
And
I
that's
guess.
a problem. to
Right, I
challenge
guess what
a
I would,
witness.
no, I hear what both of you are saying, and I think I've obviously, I'm not, there's not gonna be any rule, you can't ask questions, but I think the point that has been raised by Representative Smith and Representative Stapleton is a good one, and and what I would say is, we will not have debates, that I will not permit, but asking questions, if you have questions, I guess that's okay. I think Representative Smith's point and Representative Stapleton's point is very well taken. I would suggest that be judicious in your questions. That's what the way I
Or
would put it.
judiciary and.
Judiciary, yes.
Considerate.
And consider it, yes.
Those
for
of us
sure.
who've been on the
So,
committee.
so anyway,
Yeah.
thank you all.
you.
We debated some